My please, Lordship, who's to this petition? Due to technical problem, I want to this.
Mr. Your name, please?
Arya Ahmed, I am appearing on behalf of Mr. Anjay Datta.
Mr.
Anjay Datta. I am appearing on behalf of Anjay Datta.
Mr. So-and-so, learned counsel appearing on behalf of Mr. Anjay Datta, learned conducting counsel for the accused, submits that he has the instruction to withdraw this petition. Parallel. BA number so-and-so stands a disposal on withdrawal.
Promotion item 1. Item number 1 is wrongly listed for person. Earlier, notice that your TCR scan of TCR was called for well. TCR not yet received, madam.
Notice to the informant is yet to be.
For my verbal instruction, already notice written instruction will not have noticed.
Service report awaited. Okay, you produce it by tomorrow then?
No, scan copy of TCR.
Okay.
Scan copy of TCR.
As per office note 18, my lord, it is not received by the registry.
Okay. Heart Ms. Borman, learned legal aid counsel
Legally.
for the accused, and Mr. Borthakur, learned additional PP for the state respondent. Office note dated 1/8/2026 indicates that scanned copy of the PCR has not yet been received. Registrar shall issue urgent reminder to the learned trial court for transmitting the scanned copy of the record. And the said office note also indicates that service report is awaited. Mr. Borthakur submits that as per his verbal instruction, service is effected upon the respondent number 2. Accordingly, Mr. Borthakur is directed to produce the written instruction in this regard, and registrar shall list the matter on. After a week. 14th August.
As service has completed, my lord, for informant, my lord, some amicus or legal aid may be appointed by the court, my lord, so that next day. if
No, it
report
is
has
his
come-
verbal instruction, written instruction not received.
Lord,
May it please your Lordship. Lordship, this is a regular bail application. Here the petitioner is Lordship a license damp. He has a scab damp in the name of his mother, Lordship. That license, Lordship, will find on page 25, Lordship. And my father is a government employee, Lordship. Here what happened, Lordship, I received some property, Lordship, from a person. That is, I have given the photographs that is on page 26, Lordship. This is the person who has kept that material in my shop for the timing, Lordship. That's why I keep this photograph of this man, Lordship, with his other number, Lordship. Now, Lordship, kindly come to the FIR that is on page 17, Lordship. Neither I am named nor, Lordship, I have committed any offense, Lordship. Page 17 is the FIR, Lordship. And forwarding report, Lordship, will find on page 21.
Page 22, wrong number.
Yes, page 22, ground of arrest, Lordship. .35 kg stolen copperware, AC pipeware.
So you have received.
That this person has given me, Lordship. When this person, Lordship, I kept his photograph along with the Aadhaar card, Lordship. Aadhaar card photo.
Photograph
Because he has kept this material, Lordship. I have no knowledge this is a stolen property. That's why, Lordship, when I'm accepting this, Lordship, I have given all the photographs, Lordship.
Okay, let the city come on sort that Friday. Friday.
I live.
May it please your lordship. My lord, this is a charge sheeted case, my lord. The petitioner arrested on 21/4/2026. During the custody, my lord, charge sheet was filed, my lord. My lord, FIR is pays, my lord.
Custody for how many days?
My lord, today is, my lord, 105 days, my lord.
What are the offenses?
My lord, murder, my lord.
Let the
Hello,
scan
there are-
copy of the record come.
My lord, two FIRs, my lord, one from the petitioner side, another from the informant, my lord. So, my lord, record may be called for two cases, my lord.
Both the cases.
Yes, your lordship.
In both the cases, search it has been.
Yes, your
submitted.
lordship. Both the cases, charge sheet has been filed, and my lord, PRC case has been recorded. My lord,
What is the number?
my lord, one from the, my lord,
Hearing learned.
PRC case number,
It is provided that registrar shall call for the scan copy of the record of PRC case number 173 of
173 of 2026 and 217 of 2026. From the additional chief judicial magistrate, Sachalmara Mankar,
No, one is PRC case number 173.
173 of 2026.
The other one is
Other one is 217 of 2026.
217 2026.
26.
Arising out of Mankasar PS case number.
Oh,
First one
first,
is
first
51
one
of
from one of the
2026.
Mankasar PS case number 51 of 2026.
And the second one,
And second one is, my lord, PS Mankasar PS case number 49 of 2026.
49 of
2026.
2026, pending before the court of
Additional chief judicial magistrate,
learned
South Salmara
additional
Mankasar.
chief judicial magistrate. Mankasar,
South Salmara Mankasar.
South Salmara Mankasar, fixing the matter on
Short date may
Short.
be given.
before 15th. Before 15th, 14th of August.
Highly obliged, your lordship.
May I please, your lordship? Petitioner is behind bar for 76 days, your lordship.
For 70,
6 days, your lordship.
statutory period is
Charge sheet has been filed, your lordship. Our case is that charge sheet has been filed on 61st day, your lordship. Statutory period is 60 days, your lordship.
when he was arrested.
Your lordship, he was arrested on 25, your lordship. When produced, your lordship will kindly arrest. Forwarding. Page 49, your lordship will find. Twenty-one B, your lordship. They have shown the date and time on arrest, but your lordship will find that he was taken into custody on 25, 2026.
And where is the search sheet?
Lordship will get it at page 65, your lordship. 65. And the order also reflects, your lordship, page 62, rejection of the bail order.
Search sheet is of dated 7/7/2026.
7/7/2024,
On
but your lordship,
7/7/2026, the custodial period extends to 61 days.
lordship. On 7/7, your lordship, but your lordship, it was placed before the honorable court, your lordship, on 21st. It was prepared on 7/7.
And when it was produced before the file, before the magistrate,
Lordship, that is, your lordship. Your lordship will find that. Your lordship may kindly come to page 62. This was ordered at 27, 2026. After hearing both sides and going through the case record, it appears that the accused Liaquat Ali was arrested on 21/5/2026 at 1 p.m. and produced in the court immediately, though the charge sheet was shown to be filed on 7/7/2026, but the same is placed before the court on 12 p.m. In view of the aforesaid fact, it is found that the charge sheet has been placed in the court within 60 days. That is the court's
What
finding.
wrong with this finding?
No, your lordship, we have said, submitted that, your lordship, he was in fact detained on 20 itself by the authority, your lordship. And on 21, he was produced before the court, your lordship, showing to be arrested, and that your lordship will find from the FIR itself, your lordship. Now, secondly, your lordship has already granted bail to some of the co-accused, your lordship. The case diary probably was with them yesterday itself. One of the co-accused was granted bail by this honorable court.
So Borthakor case diary is available or it?
The record.
Where is the
will have to
order?
be called.
What is the order of co-accused?
Lord. It is BA number 1992 of 2020.
We will pass the order.
Lord.
We'll
Or your
pass the
lordship,
order.
lordship may call for the case record.
No,
your
not necessary. We will pass the order.
lordship. That is there.
No, what is the quantity of contraband substance? That is a intermediate quantity.
Intermediate quantity. Your lordship. Intermediate quantity.
Next.
Lord. Deeply over. It will be just. Yeah, for
Last.
that. Hold on.
Yes.
Lordship, it is 483 allegation is rape
Pardon?
and kidnapping. Lordship, this is bail application 483, allegation is rape and kidnapping. Record may be called.
What are the sections? What is the punishment prescribed for the same? Life. Search it submitted.
Yes, Lordship.
Let the scan copy of the record come. Scan copy of the record or SSL call for the scan copy of the record fixing the matter on 17 August.
May it please your lordship. My lord, this is a pre-arrest bail application. The two brothers are before your lordship. One is a government servant. They probably one of the brother may have informed the police, and that's why this FIR has been lodged. My lord, your lordship will find the FIR at page 20. What is it? Now, if your lordship looks into the FIR at page 20, your lordship will find in the fourth paragraph an amount of 28 lakhs 19,100. This amount, he says, from the organization Chuku Nyai Ijali. From that organization, he says that it has been received as a loan, as a first installment. Then, my lord, your lordship will find the person who was taking the loan, that name your lordship will find at paragraph number 2, Nizam Hussain. When, my lord, no security, nothing, this was an understanding between them. Then, my lord, this Nizam Hussain threatened this person that you return back those money. Then your lordship will find in the table, this money has been returned to those persons from whom it was transferred. And my name does not figure anywhere in this table. And even if your lordship looks into the table, and if we calculate it, an amount of 10 lakhs and 80,000, he himself says that it is yet to be returned back. Now, so far my allegation is concerned, your lordship will find at paragraph number 5. How to my utter surprise, on 3/7/2000, I was examined by Gelapokhuri police. He was even examined by Gelapokhuri on allegation of fraud reported by Sri Satyajit Gora. Since I reported this fraud to the police, that's why my name and my brother's name has been implicated. Your Lordship, I have annexed the ID card of my brother at page 25. And this FIR has been lodged after 15 days of the examination by the police. First, they said that they will return it. When they did not return, they had no intention of returning.
Oh, who is Satyajit Bora?
The petitioner before you, who has reported the fraud to the police.
And this identity card is of
It is his
Girish
brother. Brother's name is also there, my lord. And Sri Girish Bora in the third line.
How Girish Bora is involved with the
No involvement, nothing. Just because to put pressure on me so that I don't give my statement to the police. That's why my brother has been implicated. No way, nothing. No, even a iota of allegation. He himself admits that an amount of 28 lakhs 19,000 was received. Some amounts were returned. And he says that I reported the fraud to the police. That's why I arrested. Your Lordship will examine the case diary since it is based on documentary evidence. And this FIR has been lodged after 15 days.
after?
15 days, 1-5. After he was examined by the police threatened him. He has even, I am told, that file a complaint against the police also before the CID. Of course, we don't have that complaint before us against the IO also. Now he and the informant and the person from whom the monies were taken, they said that he will return back the money. But since he has filed a complaint against the IO against this in the CID police station, the police is not allowing that matter to be compromised.
Yes, Mr. Borthakar.
Otherwise, prima facie, my lord, thinks that my lord conspiracy between the my lord all the accused person is there because initially a huge amount deposited in his account. They are on the pretext that those were loan, my lord. Thereafter, my lord, those amounts were transferred to various other accounts, my lord. And now the my lord informant, my lord, who maybe my lord there is some they in fact all together committed this fraud, and thereafter during my lord after that. While that money deposited in the maybe my lord in the account of the informant, there is some dispute between the maybe my lord between the parties. It seems that there is a conspiracy between the parties that fraud has been committed and therefore that amount has been deposited on the pretext of loan to the account of the informant.
My lord, this presumption, your
Therefore,
lordship.
the entire dispute arises, my lord.
My lord, this presumption, your lordship will examine on production of the case diary. But till then, my lord, government servant and the brother, my lord, there
Pardon.
is,
Mr. Satyajit Bora is?
my lord,
Satyajit Bora is
is the businessman. Businessman.
businessman.
Yeah.
And other.
I have given the GST certificate of his business also. And the other is the brother government servant.
Learned Senior Counsel assisted by Mr. Learned Counsel for the applicant, Mr. Borthakar. Learned additional PP for the state respondent. Apprehending arrest in connection with Tinsukia PS case number 168/2026 under section 61(2) stroke 3082 stroke 3087 stroke 318 within bracket 2 stroke 351 within bracket 2 stroke 3 within bracket 5 of BNSS 2023. This application under section 482 of the BNSS 2023 is deferred by applicant Satyajit Bora and Girish Bora for grant of the privilege of period pay. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one Pankaj Sharma on 18/7/2026. The sense of allegation in the FIR dated so that the informant was received by Sri Satyajit Bora, Girish Bora, broker Nizam Hussain, and his associate through well-planned conspiracy. And they dishonestly induce him to part his money on the false promise of arranging finance for his tea factory, and also compelled him to transfer substantial amount to various bank accounts under different false pretext. Mr. Or learned counsel for the applicant submits that applicant Satyajit Bora is a businessman and he has reported the matter to police
Yes, my lord, about this fraud.
about the fraud, about the alleged fraud, and applicant Girish Bora is a government servant and working as agriculture extension assistant in the office of the district agriculture officer Dhemaji. And they are ready to cooperate with the investigating agency, and therefore he has contended to allow the application. On the other hand, Mr. Borthakur learned additional PP has opposed the petition on the ground that some materials are there in the FIR against the present applicants. The submission of learned counsel for both the parties received due consideration of this court. And this court is of the view that perusal of the case diary is necessary, and accordingly it is provided that Mr. Borthakur shall produce the case diary before this court on or before,
On my lord, 24.
and in the interim, it is provided that in the event of arrest of the applicant in connection with Tinsukia PS case number so and so, they shall be released on interim period as paid. On their executing a bond of rupees 20,000 with 1 surety of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. List on
26. Oblige, your lordship.
Number 6.
Your Lordship,
yes.
as a in person, I appeared before this court.
You have to inform the government and look at us on that.
Government. After some time, let the government advocate come.
Item 7.
May I please? My lord, the case of not exercising the jurisdiction by the learned CGM, my lord, the first order, my lord, will find at page 20, my lord. I, as a petitioner, my lord, am the owner of the vehicle, my lord, apply for the Zimma, my lord. Learned CGM was kind enough to pass this order, my lord. Thereafter, my lord,
Page number
page number 20, my lord,
20.
the first order of learned CGM, my lord.
So your petition for
Zimma, my lord.
was rejected.
By this, my lord, it was not rejected. Thereafter, my lord, will find we have against this order, my lord, approach to the learned CGM, session judge, my lord. My lord, session judge by order 25th, my lord, directed the learned CGM to consider my prayer, my lord. And thereafter, my lord, because of the mistake, my lord. By this order again, learned CGM has failed to exercise the jurisdiction, stating that since the case is registered under section with additional section 6 of POSCO, my lord. Relevant portion will, my lord, find at page 23, my lord. Starting from page 22.
No, you are challenging the order dated 13/7/2026.
Page 20, yes, my lord.
Page number, where is that order?
Page 24, my lord.
Yes, CGM has no jurisdiction.
My lord can see the order of learned session judge, my lord, page 23, my lord.
No, forget about the order of the session judge. I am asking you whether the CJM has jurisdiction to deal with the cases under POCSO Act.
Here, my lord, not about the case, my lord. Probably, my lord, learned CGM has mixed up with trial case with POCSO 6 additional sections with the Jimma petition, my lord. Jimma is 40503, my lord, is basically the domain of the CGM, my lord.
No, maybe, but under POCSO Act, whether CJM can exercise
my-
such power.
It is for the Jimma, my lord.
Yes,
Yes,
Jimma is also under the special act.
my lord can, for that, my lord, whether my vehicle was required for the purpose of investigation, that is there, my lord, on record. That is precisely, I am not the accused, my lord. Here, my brother was apprehended because of these sections, my lord, and thereafter my car was seized, my lord. Again, that seizure, I am the registered owner, my lord. I approach
No, you see, you have challenged the order dated 13/7/2026.
27 because of the directions of the learned session judge, my lord.
No, you show me how this order is illegal or arbitrary.
Because of the Sundarbai, my lord, and then
Because of?
the Sundarbai, my lord, because of
Sundarbai, CJM has no jurisdiction.
because of the special sections, my lord.
Hmm.
Let him file appropriate application before the special court matter. Let him file appropriate application.
503.
Yeah, before the POCSO court, special court.
I have also prepared an application before the session judge, my lord. Special court, my lord.
Hmm.
Special court order, my lord, will find at page 20, page 22, starting from page 22. Order continued up to page 23, my lord.
Maybe this order, of course, you may challenge this order.
Here I am in case 22 situation, my lord. Initially, I approached the learned CGM. CGM says I have
No,
no.
CJM has no power.
Yes, my lord.
And
then
CJM has rightly passed this order.
thereafter, I approach against this order to the special court, my lord. Special court with a directions to the CGM to consider my application. Second time he has
You
rejected.
better you do one thing.
My-
We will dispose of this petition by directing you to file appropriate petition before the special judge POCSO Act. Vishwanath.
That alternative prayer is also there, my lord, but as I have also made that prayer, my lord, my lord can dispose is absolutely no issue. Two-time CGM rejected, my lord. Learned special court has directed him to consider my petition, and thereafter the rejection, my lord, on page 24, my lord. Special judge.
Heard Mr. Tapadar, learned counsel for the petitioner, and Mr. Barthakur, learned additional to respond. This petition under article, no, under section 097. And section 503 of BNSS 2023, read with article 227 of the Constitution of India. The petitioner has challenged the order dated 13/7/2026 passed by the learned Chief Judicial Magistrate Vishwanath. It is to be noted here that by the impugned order dated 13/7/2026, the learned Chief Judicial Magistrate Vishwanath has disposed of the petition filed by the petitioner seeking custody of the seized vehicle bearing number AS 12 AB, struck AB 5269 on the ground that the case was registered under section 6 of the POCSO Act, and under the said act, the learned CJM has no jurisdiction, and therefore dispose of the petition. Mr. Tapadar, learned counsel for the petitioner, submits that against the said order dated 13/7/2026. Against this order, you have preferred.
No, my lord. Against this order, we have not approached, my lord. Straight and we have come before my lord. Against 17/6/26.
Yeah, all right, all right. It appears from the record that the case was registered under section it appears from the record that Biswanath Sariali PS case number 107 of 2026 was registered under section 140 within bracket 3 stroke 70 within bracket 2 BNS read section 6 of the POCSO Act. And as such, the learned Chief Judicial Magistrate has no jurisdiction to dispose of the Zimba petition seeking custody of the seized vehicle bearing registration number AS12 AB 5269. 5269. 5269. And as such, the impugned order dated 13/7/2026 suffers from no irregularity or illegality requiring any interference of this court. However, after considering submission of learned counsel for both the parties, this court is inclined to dispose of this petition by granting liberty to the petitioner to approach the learned special judge under POCSO Act Biswanath by filing appropriate petition seeking custody of the seized vehicle, and on such petition being filed, the learned special judge under POCSO Act Biswanath Sariali shall dispose of the same in accordance with law. You can take back this order.
Yes. I'm briefly obliged.
Because there's a petition for Zimba of a mobile phone and an original Aadhaar card. Unfortunately, call for your worship. The order is at page 18.
Heard, Mr.
Yes, only.
Learned counsel for the petitioner and Mr. Barthakur learned additional plea for the state respondent. This application under section 438 and 442 read with section 528 of the BNSS 2023. In this petition, the petitioner has challenged the order dated 26/5/2026 passed by the learned special judge Kamrup M. Rongya in connection with Kamalpur PS case number 35 of 2026 under section 319 within bracket 2, 65 within bracket 1, 351 within bracket 2 of BNS read with section 4 of the POCSO Act, and thereby rejected the petition filed by the petitioner seeking custody of seized mobile phone within bracket 1 plus Nord 256 GB plus 12 GB bearing number 7022815832 and an Aadhaar card of the petition. There is the petition and the documents lesson record, and also there is the impugned order dated 2026/5/2026. And it appears that the learned Special Judge Pakso Ramia has rejected the petition seeking custody of the mobile phone and the Aadhaar card on the ground that the police report indicates that the police report indicates that the said articles will be required for further investigation of the case. After hearing learned counsel for both the parties, it is provided that Mr. Portakur shall produce a report from the IO concerned regarding the status of the case, status of the investigation of the case. Or when sorted, Romia,
Okay.
My pleasure, of course. This petition arising out of the criminal appeal number 14 of 24, affirming the judgment dated 31/5/24 of Additional CGM Dhemaji, regarding conviction of the accused person, which was tried under section 138 of an act. Now, Your Honor, I would like to bring your attention on the page number 22, Your Lordship. Para 11, Your Lordship. May I read?
okay.
During cross-examination, PW1 has stated that in 2020, he was around 39 years old and they are wholesaler of foreign liquor. He officially joined in 2009 in the business after death of his father, and at the time of his age was 30 years. He was director in the company in 2000 and he was 18 years old at that time. He does not know whether a person below 21 years of age can involve in business of liquor as per Assam Excise Act. Income tax needs to be cleared in their business. He did not mention exact dates of transaction with accused in his evidence in SIP. There was no written agreement with the accused on 7/12/2019, the alleged date on which it was stated that there was a calculation out of which the amount of the check was fixed by the parties and a alleged check was issued in favor of the complainant amounting to rupees 13,30,990 rupees. Your Honor. Transactions are done in current account. He has denied that accused did not
Oh,
issue
where is
check.
the judgment of the additional CGM?
That is not annexed, Your Honor.
Why?
LCR has to be called for because it is. I was also in a hurry, although I have the photocopy in that.
No.
But the certificate
You
copy is
filed
not
a
there.
copy of the said judgment?
And the thing is, Your Honor, the case check was issued in the name of DS Bonded
No.
Warehouse Private.
First you bring on record that judgment.
But the appellate court's judgment is there, Your Honor.
That will not be sufficient.
But if Your Lordship allow me to show the photocopy, then I can show that.
Photocopy is not permissible. You obtain certified copy and bring the same on record by filing additional affidavit.
Right, but the additional system has already issued the notice for appearance. To the
Maybe.
18%. So it will be a very short time. So that in that period, I may be protected. Your Honor.
No order of protection at this stage. You produce the copy, then we will see. Heard, Mr.
B. Burman.
Learned counsel for the petitioner. This petition under section 438.
On Monday, it may be
442 of BNSS 2023. Read with section 528. of the BNSS 2023 is directed against the judgment and order dated 25/6/2026 passed by the learned session judge Dhemavi in criminal appeal number 14 of 2024, whereby the learned appellate court has affirmed the judgment and order dated 31st of May 2024 passed by the learned additional Chief Judicial Magistrate in NI case number 06 of 2026, convicting the petitioner under section 138 NI Act and sentence him to suffer simple imprisonment for 4 months and also to pay a fine of rupees 16 lakhs with a default stipulation. However, after perusal of the petition, it appears that the petitioner has not enclosed the judgment of the learned additional Chief Judicial Magistrate in NI case number 06 of 2026. Accordingly, learned counsel for the petitioner is directed to bring on record the judgment of NI case number 06 of 2026 by filing an additional affidavit, list the matter on
Monday?
next Monday. Next
Let-
Monday.
If my senior is in another court, therefore seeks permission to
Who is your senior?
P. Sharma.
May it please your lordship. Lordship, we are before your lordship, the praying for quashing of the CR proceeding lordship in NI case number 55 of 2024 lordship. Lordship, what happened in this case? The petitioner herein is the accused in the NI case lordship. But the second question lordship, it has been on 10/2/2024, the present petitioner lordship has reported the jurisdictional police station that he has lost his SEC lordship. This SEC number that has been mentioned in the complaint is 000014 lordship. And thereafter lordship, on 10/7/2024.
Where is the impugned order?
Yeah. No, we are praying for the quashing of the proceeding lordship along with the order dated 25/6/2025 lordship.
Where is that order?
25/6/2026 is at page 26 and 27 lordship. We are praying for quashing of the proceeding on the ground that prior to he has reported regarding the loss of the SEC lordship, and thereafter the respondent as complainant initiated the NI case lordship. And the reason of dishonor is also not insufficiency of fund lordship, is this drawer signature differs lordship, which makes the claim of the complainant doubtful lordship. And much prior to the initiation of the complaint proceeding lordship,
Okay.
on 10/2/2024, the present petitioner lordship lodged a complaint before the jurisdictional police station regarding the loss of the SEC lordship. So he has no lawful liability to be paid to the present respondent lordship as complainant in the NI case lordship. And in addition to that, lordship, the lordship has seen the page number 25 and 26. It is a mandate of law that the accused should be given the opportunity of being heard prior to taking cognizance, lordship. On that day, lordship, the prayer for adjournment made by the present petitioner as accused, which was allowed, lordship, but the cognizance has been taken without affording an opportunity to the present petitioner, lordship, to as accused therein, lordship.
Heard
have-
Mr. Didas, learned counsel for the petitioner, and Mr. Learned counsel for the petitioner. In this petition under section 528, read section 438, stock 442 of the BNSS 2023, the petitioner has challenged the order dated 25/6/2025, passed by the learned Subdivisional Judicial Magistrate Lakhimpur, North Lakhimpur in NI case number 55 of 2024, and also for quashing the entire proceeding connected thereto. Mr. Thus, learned counsel for the petitioner submits that the petitioner is arraigned as an accused in NI case number 55 of 2024 and void order dated impugn order dated 25/6/2025. The learned trial court has taken cognizance of the offense. Whether cognizance was taken by the order dated 25/6/2025,
Yes, Lordship.
where it is mentioned.
Page 27, Lordship.
Okay. Taken cognizance of the offense against the petitioner without affording him an opportunity being heard. And though the engaged counsel of the petitioner prayed for an adjournment, the same was refused. Then he further submits that before the check allegedly being issued by the petitioner was presented to the bank for encashment, the petitioner herein lodged an FIR regarding loss of the check.
Lordship.
Loss of the check. And under such circumstances, he submits that the impugn order of taking cognizance dated 25/6/2025 is illegal, and therefore he has contended to set aside the same and also contended to set aside the entire proceeding. The submission of Mr. Das needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Let me shall call for the record from the learned trial court. And interim period of the petitioner will be considered on receipt of the record on next date.
Lordship, there,
Let the record come.
only issue is that on 7th the case is fixed, Lordship. On 7th of August, Lordship, till the returnable date, can it be stayed, Lordship? Till the returnable date, Lordship.
No, we'll see the record.
Lordship, on 7, 8, the case.
Maybe you take a date on that day.
Lordship, the observation may be made, Lordship. Otherwise, we.
Yes, already dictated.
Lordship, that.
Interim period of the petitioner will be considered on next return.
One observation may be, Lordship, we may be given liberty to seek an adjournment before the trial court. Lordship.
No, that observation cannot be there. It is always there.
Lordship. I'm of Lordship.
Lordship. In this case, both the family are residing on the first floor, same floor. What happened, Lordship? Here, in page number first, comes to page number 28, Lordship. So my petitioner number 1 with her son was in that home. The nearby fled a two lady. She came, and earlier grievance they started fighting with each other, abusive word, everything, when the husband was not at home. Then subsequently she lodged FIR. The respondent number 2 also lodged FIR before the police station. Here what happened, Lordship? The NUM come to Lordship, the charge sheet they have filed. The second one, which the impugn, which now Lordship come to page number 45, like, and before that committee has been. She implicated the petition number 2 also, the 354 that part. So for the page number 45, Lordship, kindly see the FIR vote. 44, 45 is the charge sheet part we are in. Here, Lordship. After investigation of the case, have found sufficient witness to prove that on 18/4/2024 at about 8 p.m. when Jhuma Bani came to the complainant house to collect drinking water, suddenly next door neighbor.
Okay,
Sonal Anand
let
started
the
threatening-
record come.
Yes, Lordship.
Let the record come.
Let the record come, Lordship.
We will issue notice.
Yes, Lordship, record should be required. This is billable offense settle can be, matter can be settled, not at all, but 354 has been added unless. That is it, because this type of case.
No, 350, whether 354 is 354 is
No, Lordship.
compoundable offense.
Yes, Lordship. 45 page, if Lordship come to the investigation part, this is police has also mentioned. Siege in FIR, she has also mentioned. Just Nishant Anand use abusive word only. Yes, Lordship. That's why I'm coming to 45 only. Can you see that part? Just allow me to read that part only. Page 45. After investigation of the case, I found sufficient witness to prove that 18 at about when Jhuma Bani came to the complaint house to collect drinking water, suddenly next door neighbor Sonal Anand started threatening and abusing Jhuma Bani. After listening to their words, the complaint asked Jhuma Bani to enter into her room, ignoring words. When she started room, both Sonal Anand and her husband forcefully entered the room, and Sonal Anand started beating the complainant and scratching her and causing to her clothes. So Jhuma Bani also got injured, so fighting. Nishant Anand used to abusive words against them, threatened them. This is only abusive word. And here, Lordship, he was also said, page number 36, Lordship, kindly see, page number 36. Page number 36. In when I lodge FIR, the investigation on the same day that has been, page number 36. Middle. During investigation, I have visited PO, drawn a rough sketch map. PO is showing index and recorded statement of so and so. After investigation, I found sufficient witness to prove that on 18/4 at about 8 p.m. when complaint Sonal Anand was at her home with her 2-year-old son, her husband went to market. Two ladies, namely Sarvani and Jhuma Bani, knocked the door, and when she opened the door, they started using abusive words, and also they took her into Sarvani's flat, started beating her, causing simple injury to her house. So, because he is a LIC cluster officer, he was not. Son was in ill health. He went to take the medicine. They both ladies.
Okay,
That's why
okay.
Lordship only.
Let the record come. We will
Yes,
see.
Lordship.
Heard Mr. B. Sharma, learned counsel for the petitioner, Mr. P. Borthakur, for the additional preview for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has tried for quashing the criminal proceeding arising out of PRC case number 3295 of 2025, arising out of Polton Bazar PS case number 131 of 2024, pending before the Court of Learned Special Judicial Magistrate, Kamrup M, Gauhati. Peruse the petition and the documents placed on record. Let notice be issued to the respondents, returnable in 4 weeks. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Rest shall call for the scanned copy of the record from the learned trial court and list the matter after 4 weeks on
September date.
interim pair of the petitioner will be considered after receiving the record from the learned trial court.
Only the interim date, only that part. Because
Let the record come, we will consider your pair.
Okay, Lordship.
We are not
Okay.
rejecting your pair.
Yes, Lordship. Lordship, please.
My lordship. My lordship.
Yes.
I Saida Majida Begum
Mm.
as in person. I am appearing in this court.
Mm.
And
Yes.
Sir, this is a right petition criminal 33. Means, sir, I am the wife of Safiqul Ahmed, presently as a under trial convicted person in judicial custody at Central Jail, Lokhara, Gauhati. That the accused, namely Safiqul Ahmed, under trial convicted person, arrested with Azara police station, from Azara police station, and now he is in judicial custody at Central Jail, Lokhara, your lordship. That I stated that after complaint against Central Jail against Central Jail to CID and CM Vigilance, also Dispur. Then then jailer Devakamal Borua has been arrested, and two constable arrested, and with their possession drugs and ganja was seized, your lordship. Now, after that, they are continuously the jail authority providing VIP treatment to Safiqul Ahmed.
Madam, you see in paragraph number 3
Yes.
of your prayer, in point number 3 of your prayer,
Your lordship.
you have prayed for issuing direction to the CBI to
Yes,
investigate the matter.
Yes, your lordship.
But the CBI is not arrayed as a party in this petition. Unless the CBI is arrayed as a party, no direction can be issued to
Like,
the CBI.
Sir, your lordship, this violate article 14 and article 21, 17 point.
No, that's all right. But if you were insisting upon the pair number 3, then the CBI has to be arrayed as a party here. Are you willing to pursue this pair?
Yes, your lordship.
You are willing, then you have to arrayed the CBI as a party here. Hard.
No.
Toyoda Mazida Begum, petitioner in person, and Mr.
Yes, lordship.
Learned government advocate for the state respondent number 1, 2, 3, and 4. 123.
Your lordship, this violates fundamental rights, also pigeon rights.
Okay.
Kindly allow, I kindly allow your lordship through CBI, direct to CBI.
No, that's all right, but CBI has to be made a party here.
No, it's a prayer. Your lordship, it's a prayer. CBI not party. Party only state government.
Unless CBI is made a party here, no direction can be issued to them.
No, it's a prayer, your lordship. Okay. Your lordship, kindly allow next.
Okay.
I will affidavit, additional
Okay.
affidavit.
In this petition under Article 226 of the Constitution
Your
of
lordship,
India,
kindly
the
kindly to
petition
25 and 26 page number,
has
25 and
tried for
26.
issuing
Your lordship,
writ of
25 and
mandamus
26.
or any other appropriate writ or direction to the respondent authorities, especially respondent number 2 and 3, to immediately withdraw all unauthorized VIP facilities, luxuries, and illegal privileges being extended to the petitioner's husband, namely Safiqul Ahmed. Number 3, and then number 2, to direct the CBI to investigate and take strict action against any constable and higher ranking officers involved and their illegal illegally acquired assets should be confiscated. And also to direct an independent inquiry or surprise inspection by the judicial magistrate or by an independent committee into the living condition and privilege currently granted to the accused inside the prison. And also to direct the jail authorities to submit a detailed compliance report along with CCTV footage of the accused cell and visitors logs within a time-bound period. Where is the petition and the documents lesson record? Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1, 2, and 3, since they are represented by the learned government advocate. However, the extra requisite copy of the petition be furnished to them during the course of the day. Step upon respondent number 4 be taken by speed post and also by usual process within a week from today. And further, the petitioner submits that in respect of the pair number 3, she may be allowed to write the CBI as a respondent number 5 in this proceeding. So that the pair made in the pair number 3 can be considered. Pair allowed. The CBI be allied as respondent number 5 in this proceeding. And the petitioner in person shall file amended cause title within a period of 1 week from today and list the matter after 4 weeks.
Your Honor.
May I please, your Lordship? Lordship, the FIR is in page 15. Lordship, one Jyotish Nath has filed an FIR that 2 bikes have been stolen, and on receiving the FIR, the police has searched for the bike, and the bikes were recovered from my backyard. Accordingly, police has filed the charge sheet, and the case is pending in trial court. But I have been shown as absconding in this case, whereas I have never been absconding, and I have also filed an petition on the last date in the trial court.
Where is the impugned order?
Impugned order is in page 22. Subsequently, your Lordship, and NVW has also been issued against me.
Probably he was after 21/7/26. Thereafter, along that, they have that matter.
Lordship, for section 413. As I appear,
No,
I'll be arrested.
in this petition, you are challenging the order dated 18/6/2026,
Lordship,
page
my,
number 22.
Lordship, my prayer is to kindly allow me to appear before the trial court, and at least no coercive steps should be taken against me. Because due to section 413, once I appear in the trial court, I'll be arrested and put behind the bars.
No, that's all right. But how this order dated 18/6/2026 is illegal or arbitrary? Because here you have been allowed to appear on next date. So how this order is wrong?
Order not, I'm not challenging only this order. My prayer is to that any coercive step should not be taken against.
Hmm?
And I may be the prayer portion, Lordship, in page 11. And moreover, 413 is not attracted against me because not a single allegation is present in the charge sheet. They say that I am a habitual offender, I receive stolen property, but they have not failed to mention any case number, any previous cases.
Then you amend the cause title of this petition.
Lordship, subsequently, NBW has also been issued against me.
Yes, you can challenge that order.
Yes,
Lordship.
First, my lord, correct that NBW.
Yes,
Because after filing this NBW has came. I may be allowed to
bring on record, okay? Heard, Mr.
as Nag.
Learned counsel for the petitioner and Mr. Bortakur, learned additional people for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 18/6/2026. Passed by the learned judicial magistrate first class. Number 2, Srivami in JR case number 1228 of 2025, arising out of Patharkande PS case number 156 of 2022. The learned counsel for the petitioner submits that by order dated, impugn order dated 16/8/2026, the learned magistrate has allowed the petitioner to appear on next date without fail. However, on payment of a cost of rupees 500 to be deposited before the District Legal Services Authority cost fund. The learned counsel for the petitioner further submits that subsequently by order dated
21/7/26.
21/7/2026, the learned magistrate has issued non-bailable warrant of arrest against the present petitioner. But the said order has not been enclosed along with this petition. And accordingly, he submits that he may be permitted to bring on record the said order by which non-bailable warrant of arrest was issued against the petitioner by filing an affidavit, additional affidavit, and also to challenge that order. They are allowed. Recess the matter on after 1 week,
After 1.
17 August.
17 August. The petitioner shall also file amended cause title
On 12 August.
12.
12th.
Okay, 12.
Published.
Maybe it's regarding challenging the impugn order dated 6/6/2023, whereby page 38 annexure E, whereby the learned court below has withdrawn the case filed by the petitioner on a petition filed by the learned additional PP under section 321 of CRPC. This honorable court by then order dated 3/37/2026 has allowed me to file an affidavit annexing the petitions, your lordships, filed by the additional PP before the learned court below, which is annexure M page 55, your lordships. The learned court below has overlooked the vital fact that the learned additional PP has been considered the materials has been placed before the by the investigation officer, the impugn FIR.
Yes, Mr. Bortakur,
Yes,
there is one SOP.
yes.
What is provided in the SOP in respect of the cross cases?
But the SOP is also annexed in the petition, my lord. Some categories of my lord, as per that SOP, my lord, except some categories of cases, my lord. In case of my lord, where offenses are, my lord, specifically prescribed in those cases, my lord, that my lord, APP and assistant PP, my lord, they are found to, after going through the case.
No. Is there any clause there in respect of the cross cases? In respect of withdrawal of cross cases?
My lord, regarding that, my lord, there is no, in that notification, I have not found, my lord, regarding withdrawal, regarding cross case, my lord. In that notification, my lord, I have not found any.
Okay, then you go through the SOP, what
Yes.
is there in respect of the cross cases.
Yes,
We'll list the matter on Friday.
yes, my lord, Friday.
Your Lordship, but the thing is that in a cross case which is fixed for tomorrow for cross examination of PWs, if this
Cross case in session case.
session case, this is tomorrow, Your Lordships. If this case has not been, is there both are interconnected, Your Lordships. Vital evidence is there, Your Lordships. That is why if the if the subsequent cross has been proceeded, Your Lordships, the petitioner and the accused person will be highly prejudiced, Your Lordships. That is why, Your Lord, till Friday, Your Lordship, I will only for interim, Your Lordships. That is my humble prayer,
Friday.
Lordship. Till Friday, Your Lordships. Or
Okay, on that day, we will consider your pair.
no, Lordship, because tomorrow is the date fixed for cross examination, Your Lordships.
Tomorrow they can take adjournment, my lord, on that tomorrow. my lord.
Tomorrow.
Tomorrow they can take adjournment, my lord.
There is an observation may be made, Your Lordship, but
Regarding?
that observation may be required, Your Lordship.
Then
But
they
but
can
till Friday, Your Lordship, that
You file an application for adjournment there.
that observation.
Round is my lord, we have to go because if my cross case, if my both are related, one case is already withdrawn. And regarding that cross case, I will have to look into that.
The vital fact has been, the facts has been asserted in this case, Your Lordship. That has not been, without considering that vital fact, this case has been withdrawn, Your Lordship. That will hamper the subsequent case. That is why I pray before this honorable court for an interim measure, Your Lordship.
Tomorrow, my lord, there is no difficulty for him. He can file application court.
That may be not being considered, Your Lordship, because the learned court below has said that since there is no direction or interim protection has been granted to me, I cannot allow you to stall the proceeding, Your Lordships. That is, it will be straightway reject my application. That is my apprehension, Your Lordships.
Heard Mr. S. Bora, learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. Pursuant to the order dated 38/7/2026, Mr. Borua has bring on record the application dated 6/6/2023 filed by the learned APP before. Is it by APP or additional PP?
It is additional PP. Your Lordship.
APP,
Additional. Yes,
by additional PP,
and assistant PP also, my lord.
additional
APP
PP. Before the court of learned JMFC. JMFC. Rongya. Rongya. After hearing learned counsel for both the parties, it is provided that Mr. Borthakur shall go through the SOP prepared by the state respondent for withdrawal of the petty cases. Petty cases. And apprise this court on next Monday as to whether there is any provision of withdrawal in respect of the cross cases. Cross case. Mr. Borua, learned counsel for the petitioner, submits that the cross case is fixed tomorrow. Cross case being, what is the number of the case?
Special P case number 10/28, 18. Special POXCO, Your Lordships. Pending before the additional session, Judge, Your Lordships.
But the problem is that since POXO is there, without issuing notice to the other party, we cannot grant you any relief.
Yes.
Notice may issue, Your Lordships. It is notice by issue.
My lord, otherwise, POSCO cases, my lord, that cannot be, my lord, withdrawn. But as per the SOP, those are. If
No, no,
POSCO
no,
is-
no. The withdrawn case is not of POCSO. It is of petty offenses
Yes.
under IPC.
That case, my lord,
Cross cases is
cross case, my lord, how that can be, my lord, withdrawn, because POSCO is already there. POSCO cases cannot be withdrawn, my lord.
no.
In other case, POCSO is not there. POCSO was not there.
Yes. POSCO, then, yes, my lord, really. তোমাৰ এই উদ্যোগটো কেছ হ'ল
এইটো এইটো molestation আছিলে molestation টো নাচাই পেলাই আমাৰ এইটো উইথড্ৰ কৰি দিলে এছঅপিত কিন্তু molestationৰ কথাটো আছিলে কিন্তু আমাৰ ক্ৰছ কেছটো কাৰণে এইটো চলি গ'ল মোৰটো বন্ধ হৈ থাকিলে
কি ক'লো লাইনটো? What is the number of the cross case?
Special POSCO case number 10/2018 pending before additional session judge Kamrup Rongia.
For cross-examination of the witnesses, and if the witnesses are cross-examined, then the petitioner herein would suffer serious prejudice, and as such, he has contended to stay the proceeding of special case number so and so so and so. Since in this matter notice has not yet been issued, and since there is also since the said case in the said case the POCSO offenses are also involved. Without hearing the respondents, respondent number 2 and 3, this court is not inclined to grant the interim pair of the petitioner. However, the petitioner will be at liberty to file an application for adjournment before the learned trial court, and in the event of filing such an application, the trial court shall consider the same in accordance with law. List the matter on Monday. You file an application there, the trial court shall consider the same.
May I please your lordship? Lordship, I am challenging an order which is in page number 25. What is the crux of the case is that I was the informant, and on the basis of my FIR, lordship, case was registered and charge sheet was being filed. During that process, lordship, I applied for a seized articles, lordship. And the court opined that these articles cannot be taken away because the appreciation of the ownership is not being proved, lordship. Here I'm not on that fact, lordship. Appreciation is okay, lordship. But here the observation is that whether articles are mine or not, that part, if lordship has decided, the learned trial court decided in the initial stage that the ownership of the property is not mine, then the whole case is futile, lordship. The institution of that case, lordship. On the basis of my information, lordship, charge sheet is being filed. Police has filed the charge sheet only on the basis that my articles is being seized. And when the learned trial court has stated, lordship, the articles are not to be, no, it is not found that it is not me, it is not mine, it is to be appreciated. But in that case, I think, lordship, so in one case,
What are the articles?
some gold articles are there. Gold articles are there.
Your lordship, may kindly use page 26, paragraph 5, man. Is the order of the learned.
Page 26.
Page 26. Serial number 5, madam.
Yes.
Already in this case, started already submitted, madam.
Yes, that is, I am not disputing that part also.
Investigating officer in his report.
The report is not, it is part of the charge sheet also.
Person submitted that they stole jewelry from the house of the informant. But that's not a specific the items that has been spent. Some of the jewelry has been made. That the identity of the ownership can determine. Only was the application of evidence during trial.
In that case, lordship, if this opinion is being made initially, lordship, before starting of the trial, lordship, then in fact the accused are being exonerated, in my opinion, lordship, as per my understanding, lordship. Lordship, here appreciation, no doubt, lordship, appreciation is-
Since the articles were melted,
The
No.
Lordship, but
How can you identify it
then
as
also,
your
that
article?
that's true, Lordship. But police has filed a search sheet. Along, considering my statement to be true, police has filed a search sheet. The police has given a search sheet. Police has gone to the court with an evidence with my state, with me, Lordship, that this is on my. If these articles are not mine, then accuser is scot free in the trial court, Lordship.
No. Trial court has never formed such an opinion.
Lordship, here, Lordship, my got it here, Lordship. Trial court has stated that, Lordship may go through this order, Lordship, page 25. Trial court has stated that the articles informant but has not identified specifically which were the items. If items are not being identified, then what is the use of being being the institution of a constitutional trial, Lordship?
No,
Because
no.
on the basis
no,
of
no.
my articles are being stolen only for that.
How, on what basis the investigating officer has seized the articles? That has
Only
to
on the
be
basis of my identification. It is in the search sheet, Lordship. Search sheet, I think it is in the page, it starts from page number 15, Lordship. Here, Lordship, I'm page 19, Lordship. I'm going to that part, Lordship. On 15 January.
Why the interim custody cannot be given to him?
My lord, yes, that can be, my lord, otherwise, my lord, there is an observation of the trial court, there is those, the identity of those, my lord, may get gold also, my lord, on the.
No, you say
Interim
those
letter, I
articles
agree
were
with
seized on the basis of one FIR lodged by the petitioner.
Yes, my lord.
And after due investigation, the articles were recovered and seized.
Yes.
So prima facie, it appears to be of the petitioner.
Your lordship may kindly again come to page 27. 27 was the last part of the order, my lord. The petitioner may,
26.
my lord, last line, my lord. The petitioner may so advise renew the prayer for custody after relevant evidence regarding ownership is recorded during trial part, lord. That is the.
At what stage the case is pending now?
No, it is not started, Lordship. It is in the evidence. I mean, it is not started, Lordship. Yeah, Lordship, my condition is, we learn, Lordship. Interim protection is there. We have to give a bond, Lordship. In that case, trial court can go for it. We may return it also. We have to enter in the trial also as an informant nowadays. We have to prove it in the trial. But here in the initial stage, if the trial court opined it cannot be mine, then in one, either way, they are being exonerated.
We will call for the record, we will see.
Yes, yes.
Heard Mr. Sharma, learned counsel for the petitioner. Mr. Borthakur, learned additional PP for the state platform. Order dated 8/10/2025 passed by the learned judicial magistrate first class Kamrup M. Gauhati in PRC case number 789 of 2025 is challenged in this petition under section 528 of the BNSS 2023. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition number 5216 of 2025 filed by the petitioner under section 503 of the BNSS 2023 seeking custody of the seized ornaments of gold. After hearing learned counsel for both the parties, it is provided that after hearing learned counsel for both the parties, perusal of the case record is found to be necessary to dispose of this petition, and accordingly it is provided that Registrar shall call for the scanned copy of the record from the learned trial court fixing the matter on before 15 August. 13th of August.
Is process. In my opinion, Lordship, in my prayer, Lordship, if Lordship, let the proceedings also may be stayed, Lordship, during this process.
Why?
Because, Lordship, if this opinion is there, Lordship, it will be benefited for the accused, Lordship.
Your pair is not rejected by the learned trial court.
Yes, Lordship.
You have been granted liberty to file to renew your pair at appropriate stage. That means after recording
Yes,
of
Lordship.
evidence.
Lordship, okay. Lordship, it's obliged, Lordship.
Okay. We'll resume after 5 minutes.
Oblige lordship.
May it please your lordship. Your lordship, in this case, section 379 was included of the IPC. Thereafter, due to his financial and economic purposes, he migrated to Kerala, your lordship, and he was unable to participate in the trial. However, now he has returned back, but there is an NBW and the PNA which is issued against him. He is ready to cooperate in the trial and participate in the trial, your lordship. Page
When the
number,
next date is fixed.
your lordship, in page number 36, you will find an order which says that the case has been put up in file and no next date are fixed, your lordship. In page number 36 is the order. Page number 36, order dated 23rd 12 2025. And in page number 35, your lordship may kindly peruse the order dated 6/8/2025. It is stated that a report of warrant received against the accused person stating that the accused person presently resides at Kerala, hence warrant of issued against the accused person could not be executed. Now he has returned back to the state of Assam for very poor person, your lordship. Just for livelihood purposes, he was in Kerala. He was unable to receive the notices and summons, your lordship. He is ready to participate in trial.
Heard, Mr.
TL Hospital.
Learned counsel for the petitioner, Mr. Balthakar, learned additional PP for the state respondent. In this petition under article, under section 528 of the PNSS 2023, the petitioner has challenged the order dated 23rd 12 2025. Passed by the learned Chief Judicial Magistrate Baksa Mosolpur in PRC case number 129 of 2021, arising out of Tamulpur case number 254 of 2020. It is to be noted here that by the impugn order dated so the learned Chief Judicial Magistrate Baksa
Baksa, your lordship.
has issued a standing warrant of arrest for non-appearance of the present petitioner. And thereafter file the case till receipt of report. Of reminder or production stroke appearance of the accused person. Learned counsel for the petitioner submits that the petitioner was residing at Kerala for quite some time for the purpose of his livelihood, and thereafter he came to know about the impugn order dated 23rd 12 2026, and that the petitioner is willing to participate in the proceeding of what is the number of the case?
Lordship, PRC.
PRC case number 129 of 2021,
PRC.
and SS. He has contended to
Case number 129/2020.
interfere with the impugn order dated 23rd 12 2025. Mr. Bortakor, let him appear and face trial.
Yes.
Mr. Bortakor, learned additional PP, submits that the petitioner may be allowed to participate in the proceeding of PSO case number 129 of 2021. So after hearing learned counsel for both the parties, this court is inclined to dispose of this petition by directing the petitioner to appear before the learned Chief Judicial Magistrate Baksa Mosolpur on or before 20th August, and to file an application for allowing him to remain on. No, you were on bail earlier.
Earlier, I was on bail, your lordship.
Either to remain on previous
on
bail
previous
or
bail.
to allow him to go on fresh bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, the non-bailable warrant of arrest issued, the standing warrant issued against the petitioner shall be kept in abeyance.
Deeply obliged.
In terms of this criminal petition, discuss the purpose of.
Deeply obliged.
Lordship may peruse annexure 2 at page 24, your lordship. Yes. It is a petition of a complaint case, your lordship, under the Domestic Violence Act. I am representing the respondent number 2, 3, and 4 here, your lordship, not 1. Now, lordship may peruse paragraph 5 to this, your lordship. at page 26. The respondent number 2 is lived in the said village. The respondent number 1, whom I am not representing, started extramarital affairs with the respondent number 2. Respondent number 3 are the brother of respondent number 2, and respondent number 4 is the daughter-in-law of respondent number 2. Here, in fact, your lordship, there was an FIR as well against these people, your lordship. In that FIR, only the respondent number 2 was charge sheet, 1 was charge sheeted, and the others, against the others, there was an FIR, your lordship. I have annexed that as well. It starts from, and after that FIR, your lordship, she has again filed this DV case, your lordship, implicating all the co-villagers. It is her allegation that there is an extramarital affair and they are residing in the same village.
Co-villagers.
Co-villagers, your lordship. The charge sheet also, your lordship, which is starts from annexure, which starts from page 15, your lordship.
No, whether the co-villagers can be
Lordship,
implicated.
that is the ground precisely. There is no domestic relationship and they have never ever shared a household, your lordship.
Hmm?
That is the ground of challenge. Only by those 3 persons, not by the respondent number 1. I am not representing that person, your lordship. In this next page 15 charge sheet, it was charge sheeted against Kamal Chandra Roy at page 16. And page 17 and 18, lordships can see particulars of accused person not charge sheeted. Bhadrashwari Roy, Manoj Kumar Roy, page 17 and 18. And after this, your lordship, this TV case, your lordship, implicating all this person and his family members as well.
Heard Mr. Mukherjee, learned counsel for the petitioner. In this petition under section 528 of the BNSS 2023, the petitioner has tried for quashing 3 petitioners, namely Bhaddeshwar Roy, Srimati Bhaddeshwari Roy, Manoj Kumar Roy, and Srimati Namita Roy have tried for quashing the seer between bracket DV case number 13 of 2026 pending before the Court of Learned Judicial Magistrate First Class Bongaigaon. Mr. Mukherjee, learned counsel for the petitioner, referring to the annexure 2, the complaint in DV case number 13 of 2026, especially to the paragraph number 5, submits that the petitioner number 1 live in which place he is living?
Lordship, this is the same village, your lordship. Kharija Dolaigaon part 1, your lordship.
Kharija Dolaigaon part 1.
Part 1. District Bongaigaon.
Then respondent number 1 has started extramarital affairs with the respondent number 2. And respondent number 3 is the brother of the respondent number 2, and respondent number 4 is the daughter-in-law of the respondent number 2, and they have no domestic relation with the respondent number, with the respondent herein. Respondent herein. And as such, they have illegally been arrayed as a respondent number 2, 3, and 4 in the domestic violence case number 13 of 2026. And therefore, Mr. Mukherjee has contended to quash the proceeding of domestic violence case number so and so pending against the present petitioner. The submission of Mr. Mukherjee needs further consideration at this stage. Notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Justice shall call for the scanned copy of the record of DV case number so and so from the Court of Learned Judicial Magistrate First Class Bongaigaon. And further, considering the submission of Mr. Mukherjee, learned counsel for the petitioner, further proceeding of the DV case number 13 of 2026 pending against the present petitioners stands state till returnable date, list of referrals.
My lord,
Yes.
in this case, my lord, the petitioner is a chairman of Tangangari Samaj Committee Limited. Suddenly, he received a notice on his WhatsApp. It is said to be sent by the IO of Damdol Police Station and directing me to appear before him. But no case, nothing has been mentioned in that said notice. Your Lordship kindly see page 11 is the notice. I have no why, which case, what is the offenses, nothing has been, only on the basis of GD&T, and that to serve in my WhatsApp.
It's a Bortakor.
And annexer 2, my lord, and Honorable Supreme Court in various cases held that WhatsApp messages will not. It is the judgment, my lord.
Intention of the IO to address the petitioner and for which 35 and
Yes, sir,
regarding
yes,
the
sir.
contents of the ED entry number is there, madam. And in 35(3) notice, madam, there is no requirement of furnishing detailing counsel case. And here,
Physical-
35(3) notice,
physical-
that means there is no intention to add the present petitioner.
Physical notice is must, my lord, illogically is that judgment. Honorable Supreme Court time and again held that. No, nothing. What is the offense? I don't know. What is if there is a non-billable section is there? Definitely I will be inside. Illogically,
Mr. Ahmed, you see, this is a notice under section 35(3)
Three.
of BNSS.
Yes.
So,
Illogically see.
the IO has issued this notice. It
For
means
what
that
purpose?
he is not willing to arrest you.
If he will not arrest, is observation, this was, I have no objection, my
No,
lord. I
no,
will appear,
that
he will
is,
certainly arrest me, my lord.
issuance of notice, under section 35(3) is the intention that he will not arrest you.
My lord, just a moment, illogically see the judgment. He
No.
cannot do it, he cannot send it WhatsApp, he should, a physical notice to be served.
Mm.
Supreme Honorable Supreme Court held that. Physical WhatsApp notice will not serve the purpose. Notice must be served physically, my lord. This is the whole finding of the Honorable Supreme Court. Now it was page 13. The state government also issued a notice. That all the police station to you serve physical notice. Page 13, my lord. This is a notification, my lord.
Page number?
No.
Page
Sorry,
number-
my lord. It is, my lord, E2. Oh, itu tuh bisa. Itu notification sekarang. Hah? Notification? Notification sekarang naik. This is the one, my lord, illogical issue. State government issued a notification directing all the affairs to you did not have notice through WhatsApp. You must serve is physically, my lord. In person of the Honorable Supreme Court judgments.
Heard, Mr. J. Ahmed, learned counsel for the petitioner, and also heard Mr. Bortakor, learned additional counsel for the state respondent. Which is the relevant provision?
My lord, if you look at the judgment, clause B, page 55, and that notice mentioned in the judgment, my lord.
Okay.
What? It is this, and our High Court, Honorable High Court also stated the similar nature of cases.
No, in the standing order, in which clause it is mentioned?
4.2,
4.2, I think.
4.2.
Yes, my lord. And it has been mentioned in the Supreme Court judgment, page 5. It was a mention code. Il also can see criminal petition 243 of 2025 of this honorable court. Similar nature of case, this honorable court quashed the notice. I refer the judgment.
Notice has already been issued. Let him appear when he concepts to that notice before the.
He cannot, he let his serve physical notice, he
No,
serve,
no,
I will
Mr.
appear.
Borthakur, you see, this as per clause 4.2, it is stated that notice under section 41A CRPC stroke section 35(3) BNSS 2023 must not be done through WhatsApp or other electronic mode.
Yes, madam.
So,
Regarding that, my lord,
Uh,
we'll have to get the instruction whether any other method also. He has started the notice, madam. That is the submission of the petitioner that only through WhatsApp. Maybe my some. Other manner also.
okay. It is petition under section 528 of the BNSS 2023. The petitioner has right for quashing the notice under reference number Dharamtul PSGD entry number 11 dated 23rd June 2026 issued by the IO of Dharamtul PS Morigaon to the present petitioner through WhatsApp. Mr. Ahmed, learned counsel for the petitioner, referring to the standing order dated 17 February 2025 issued by the Government of Assam Home Department, Dispur, Gauhati, especially to clause number 4.2, submits that police officer is not entitled to serve notice under section 35 within bracket 3 of BNSS 2025 through WhatsApp or other electronic mode. And in support of his submission, he has also referred to a decision of Honorable Supreme Court in the case of Satinder Kumar Antil versus Central Bureau of Investigation and another, reported in 2025 0 AIR within bracket SC 10 page number 1023, especially to paragraph number
Paragraph 1 is 11, page 4.
paragraph number 11.
11 A, B, C, D.
And also a decision of a coordinate bench of this court in Solingso Kora versus State of AP and 5 others in criminal petition number 243 of 2025. 2025. Per contra, Mr. Ahmed has contended that the impugned notice is illegal and arbitrary, and therefore he has contended to set aside and quash and set aside the same. Per contra, Mr. Borthakur submits that he may be allowed to obtain necessary instruction as to whether the any notice was served upon the petitioner by physical mode. Where allowed, recess at least the matter on next Tuesday.
Yes.
Tuesday. Until then, the impugned notice dated so and so stands state.
Number 41.
With an exit order saying the review proceeding, we file an application for vacating the stay order. Last order was kindly see instead of placing that application, it is directed that the entire matter may be taken up on that. (24/7) order.
So we have to hear this criminal petition.
Select the order.
May it please, Your Lordship. Also, in this case, I'm for the petitioner. The petitioner number one is the husband and the petitioner number two is the mother of the petitioner number one. Now, the respondent have filed a DV case before the JMFC Gauhati, Your Lordship. And subsequently, it has been, the proceeding has been stayed by this honorable court, Your Lordship.
Where is the complaint of the domestic violence case?
Lordship, it is at
Page
page
number?
number 208, Your Lordship.
Page
is the-
number?
208 of my petition, Your Lordship. That is the petition filed before the learned court below the domestic violence petition, Your Lordship. Annexure 16, page 208, Your Lordship.
And this proceeding has been stayed by this court,
Proceeding has been stayed by order dated 8/12/2025, Your Lordship.
25.
Lordship.
So what are the grounds for quashing the proceeding?
Lordship, if I go through the brief facts of the case, Your Lordship. The petitioner, they got married in the year 2010. It's basically on 3/7/2010 they got married. However, in the month of November 2012, Your Lordship, the petitioner number one was diagnosed with limb girdle muscle dystrophy. It's a progressive muscle dystrophy, Your Lordship. And as on date, the petitioner number one is 80% disabled. He doesn't have the power to move by his own. And that apart, in 2014, the marriage of the petitioner has been registered before the sub-register, marriage register, Bangalore. Then they have a son on 14/12/2014. They got a son out of their said wedlock. And Lordship, the conduct of the respondents, if your Lordship kindly takes up my petition, more particularly paragraph number page 6, Your Lordship. All along, Your Lordship, the respondent and in fact the petitioners, they are not having a conjugal life. They are having disputes right from the day of their marriage, Your Lordship. And Lordship, the respondent, she left the matrimonial house in the month of November 2020 to April 2021. She herself have left and she have accommodated herself in a different flat, nearby flat at Bangalore, Your Lordship. Then, Your Lordship, on 30/9/2002, again the respondent, she left the matrimonial house along with the child and valuables, including the car of the petitioner. Then subsequently, Your Lordship, on 13/2/2023, the respondent files a divorce petition before the family court, Bangalore.
seeking a divorce decree in between the petitioner and the respondent. And she has also filed a petition for granting custody of the son, which is still pending before the Bangalore court. Now that apart, your lordship, in May 2024, the respondent again left Bangalore along with her minor child. And the minor child was admitted mid-year in a school here in Gauhati. Then, your lordship, the Honorable Court at Bangalore has granted interim relief to the petitioner for visitation of his minor child, and that apart to pay a maintenance of rupees 15,000 per.
The respondent herein has filed objection, and a copy of the same is furnished to the petitioner, no, to the accused, and she may be granted some time to go through the same. And she also submits that the matter may be listed for hearing. They are allowed, list the matter on
24th August.
24th August. Is there any interim? No, this is BA.
Yes.
Okay.
Then 20.
Much applies.
Lordship, we will be filing the additional affidavit by today. Kindly matter may be listed after 2 days.
You have filed additional affidavit
Yes,
today.
Lordship.
Not order, madam. They are supposed to file on additional evidence, bring on record, madam. They can-
Okay.
This is how many-
Pardon me, your name please?
C. Gogol.
Learned counsel for the petition, for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. The learned counsel for the accused submits that, the accused has filed one additional affidavit bringing on record the statement of witnesses made before the trial court, and she places for listing the matter after 2 days.
Yes, Lordship.
They are allowed, list the matter on.
14 August.
No, BA.
13 12 August. And then 30.
Lordship, in this matter, counsels are at lax, Lordship. Kindly matter may be passed over for time limit. I'm on behalf of S. Nawaz.
31.
May I please, your lordship? For 83 application, my lord, I am behind the bar 178 days, my lord.
You are behind the bar for
178 days.
178.
There, my lord, section 12 of the POCSO, where maximum punishment is 3 years. Other sections are, my lord, all 3 years, except, my lord, at least kidnapping, my lord, it is 10 years. My lord, actually, what happened, my lord,
What is this? The case is pending.
evidence
Evidence.
stage, my lord. But evidence not yet started, my lord. My lord, actually, my sisters, I am the son
But
of my,
you have
my,
been searched.
my mother and the accused mother are the own sister, my lord. And there was the development of some love affairs, my lord. The girl was from school going, my lord, class 12 years, 15 years, my lord. And there is allegation of kidnapping, my lord. And now we have proposed, my lord, that after the grown up, my lord, after completion of the education, they will be married, my lord, because it is the within the relationship, the as per the Muslim people, they can marry a sister's son also, my lord.
Madam, your answer is fine, but to inform me.
Mm.
I have no objection. Get it.
Yes, Mr. Sharma.
Minus. Here is the minus, lordship, kindly please, minus. Here is the minus. Eight witnesses, minus in the search sheet, minus.
Yes.
Out of 8 minus, 1 informant was examined, minus. On what happened on the table, on the informant schedule, there is no any, minus, objection if bill is granted by considering some, that is German PW1. Thereafter, victim is yet to be examined, madam, and in his victim balance, he has categorically been stated, madam. And event balance, it was earlier 2 times.
Victim is examined.
Not examined, madam. Victim not is examined. In her 182 statement, madam, he has categorically indicated the present position, madam. And balance, it was 4 below 2 times.
33.
Please, your lordship. Today 73 days is behind the bar, madam.
But FIR is phase my lord. Phase 9 is the affair. But respectfully wish to state that taking the advantage.
Sarsit,
73.
under section,
Allow me. He will face the
under
time.
section,
Under section minor. Not mentioned, but if you put it in the 64-1, 75 to 79, 51.
what are the punishments?
Minor. 64-1 imprisonment for life.
Merit,
Life,
merit domain, my lord. Both are merit, my lord.
maybe.
Well, he will face the trial, my lord. Under any terms condition, my lord, may allow. 73 days he is behind the bar, my lord.
You go and approach the trial court. Or Mr. Uddin, learned counsel for the accused, and Mr. B. Sharma, learned additional PP for the state respondent. Anybody for the informant here?
My lord,
Informant is not a party. This application under section 483 of the BNSS 2023 is preferred by accused Habezuddin Ali, who has been languishing in jail as of since 24/5/2026 in connection with Matia case number 54 of 2026 under section 64 within bracket 1 stroke 75 within bracket 2 stroke 79 stroke 351 within bracket 2 of BNS. Mr. Uddin, learned counsel for the petitioner, submits that the accused is languishing in jail as for 73 days and that the accused and the victim both are married and married and that the accused will face trial and therefore he is contented to allow this petition. On the other hand, Mr. B. Sharma, learned additional page submits that though CD was called for by order dated 21st by order dated 30th/6/2026 and 21/7/2026 the same has not been received, but as per his instruction the IO has completed investigation and submitted charge sheet being charge sheet number
66 or 26, dated 21/7.
21/7. And since charge sheet has been submitted against the present accused, and since the offenses alleged in the FIR are serious in nature, this court is of the view that this is not a fate case where the privilege of bail can be granted to the accused, and accordingly the petition stands dismissed. However, the petitioner is granted liberty to approach the learned trial court after recording the evidence of the informant struck victim. You file an application after recording the statement of the victim called there trial court.
Well, it maybe takes some more time to record the statement. Well, without that observation, maybe direction, my lord, if
Pardon?
possible. That victim, my lord, sometimes it take more time because address and notice sometimes is not served. So, my lord, if possible, my lord, he will file and as per law, court will decide. My lord.
So let a
Otherwise,
statement of the victim girl
if
be
this
recorded.
direction is not available in the order, then bail will not allow at that time.
No, you see,
If other
the
condition
offense is
also put-
serious, punishment is life.
Yes, my lord. If my lord, he will file, my lord, that court will consider as per law, my lord, without observing it. I am obliged to.
Bandi. Petitioner is your lordship behind bar for 51 days, your lordship.
Pardon?
These are your lordship
How many days?
51 days, your lordship.
51 days.
FIR is at page 12, your lordship.
What are the offenses?
Offense, your lordship, under section 118(2), then 142, that is kidnapping, they say is your lordship, and 3085 extortion, and 331(8), house trespass, your lordship, and organized crime. 2, that is organized crime, that's what I have stated. Now, your lordship will kindly come to the FIR at page 12, your lordship. May I read, your lordship? নমস্কাৰ গ্ৰহণ কৰিব আপোনাক সন্মান সহকাৰে জনাও যে যোৱা ইংৰাজী 10/6/2026 তাৰিখে বুধবাৰে নিশা প্ৰায় 10:30 মান বজাত আমাৰ উদ্দীপ্ত এনাৰ্জি এণ্ড ইকুইপমেণ্ট প্ৰাইভেট লিমিটেড কোম্পানীৰ NC গাঁৱৰ প্ৰগতি পথৰ DC কেম্পত থকা অৱস্থাত নিশা বলপূৰ্বকভাৱে প্ৰৱেশ কৰি মোক শ্ৰী so নেতৃত্বত ৰিণ্টু দত্ত, যদু বৰা, প্ৰদীপ বৰা, মৃদুস্মিতা ফুকনৰ লগতে একাধিক ব্যক্তিয়ে জোৰ জবৰদস্তি টানি আজুৰি গতিয়ে দাবী ধমক দি শাৰীৰিকভাৱে আঘাত কৰাৰ লগতে গাড়ীত উঠিলে প্ৰাণে মৰাৰ ভাবুকি দি প্ৰথমে বগাই গাড়ীত উঠাই লৈ যায় আৰু মোৰ লগত থকা ইমান 40,000 টকা কাঢ়ি লোৱাৰ লগতে ডিঙিৰ সোণৰ চেইনডাল, মানৰ মূল্যৰ চেইনডাল দিব্যজ্যোতি বৰুৱাই কাঢ়ি লোৱাৰ শেষত দুলীয়াজান আৰক্ষী থানাৰ গেটৰ সন্মুখত গাড়ীৰ পৰা দত্তই নমাই আঁতৰি যায়। ইয়াৰ উপৰি মহাৰত্ন কোম্পানী অইল ইণ্ডিয়া লিমিটেডৰ অন্তৰ্গত আমি ঠিকাভিত্তিক ৱৰ্ক অৰ্ডাৰ কাম কৰি থকাৰ সুবিধাত অপাৰেশ্যন এটা টুলছৰ দল লৈ যায় মোৰ ৰুমৰ বাহিৰৰ পৰা এই মহোদয়ৰ হাতত জনাবলগীয়া। Now, your lordship may kindly come to my additional affidavit, your lordship. In fact, I have narrated what has happened at page para 5, your lordship. That on the date on which the alleged offense, para 5, my additional affidavit, your lordship. This was not brought, your
No,
lordship.
that is your defense. Can we consider the same at this stage?
Lordship,
Can we consider your defense at this stage?
lordship. Now, pardon, your lordship.
That is your defense.
Lordship.
Can we consider your defense at this stage?
No, your lordship. Ultimately, it will be in the trial, no doubt about that, your lordship. But only thing, your lordship, what he has stated, your lordship, is not correct, your lordship. We have not gone there. At least
No,
I have not gone there to do that, your lordship.
We are to consider the statement of the witnesses
Lordship, that your lordship.
examined by the IO.
Lordship. That your lordship will go through. Your lordship, and 51 days behind bar, your lordship, already thoroughly interrogated, your lordship. In fact, he has not gone there with that intention, your lordship. That is what I
What
have
is the punishment for the organized crime?
90 days, your lordship, is the maximum period of detention.
No, no.
Lordship. Punishment, your lordship, not less than 5 years, which may extend up to life imprisonment for life. Not less than 5 years, and which may extend up to imprisonment for life.
Bhartakur, is there any material against the present petitioner?
Statement of the company, but several witnesses are there in the case diary, my lord.
And what is the stage of evidence? Sorry, investigation?
But the investigation, my lord, otherwise, my lord, investigation sufficiently progressed, but some of the accused were not yet arrested, they are absconding. And regarding the present petitioner, my lord, earlier also there are 2 cases registered against the present petitioner. Duryodhan PS case number 239, 2000.
Is habitual.
No, that's your lordship. What has happened? There are certain allegations against in the general FIR against your lordship, Lasit Sana members, your lordship, where during 1 year back, your lordship, large number of FIRs has been 1 day or within 2 days have been registered. In that general FIRs, your lordship, his name came up, your lordship. This is your lordship, what my instruction is, your lordship. He belongs to that organization, your lordship. And your lordship, sometimes they go
organization?
overboard, your lordship. I will have to honestly admit that.
Who is organization?
Bir Lasit Sena, your lordship.
Bir Lasit Sena.
Yes. Sometimes they go overboard, your lordship, no doubt about that, your lordship. I will have to admit it, your lordship, that they should not
So
have.
if
but-
you, if we enlarge you on bail, then again you will
No, your
indulge in
lordship,
similar
I impose
activities.
Stringent condition, I will abide by that, your lordship. I will abide by that, your lordship.
Okay, we'll see.
Young boys,
So
your
Bhartakur,
lordship.
Today is
CD.
51.
Lords, 51 days behind by the
CD.
lords.
After some time, authorized is absent. After some
NCB.
NC1.
Finally, 30. May please, your lordship. Lordship, the learned amicus curie has just informed me that yes, she's in legs with court number 25 after some time.
My lord, this was a copy has been given to the Bhagavad Gita.
Yes, CD has been received here this year. Okay. So what is the stage?
Box office lordship, 5 out of 5, the 5 witnesses are there, lordship, and out of 5, 3 witnesses examined, including the victim, and victim has implicated him, lordship. And
Two
six
witnesses has been
one in 183 and in 3, lordship. Two independent witnesses are yet to be examined.
Total 5 witnesses have been cited in the search sheet.
Lordship,
3 have been examined.
3 examined, lordship. Informant, murder, and herself.
victim.
So since the material witnesses have been examined, can we consider his petition? For how many days you are behind the bar?
My lord, it has become to about 200 days, my lord, already.
200?
200 days, my lord.
200 days. And where the case is pending?
Additional session judge, spokes official, additional session judge, my lord.
Where?
Is session court, my lord.
In which place?
Additional, what it come to my lord.
Kamrup.
My lord.
Okay.
See, the victim herself has implicated this person, lordship, and there is a possibility of conviction, lordship. And
Possibility of?
conviction, lordship. This is if there are the possibility of dumping over the dignity, lordship.
No, my lord, we will not,
Lordship,
we will not temper the evidence of my lord, if I give his bail is granted, my lord. And considering that, annex chapter 8, my lord, in page number 8, the accused may be released on bail, my lord.
Yes, madam, anything to submit?
The apparently accused person will also, the victim is 16 years old.
My village lordship, service completed lordship, 39. Not appointed.
MRKS.
What happened, my lord? My lord, father-in-law's lost this affair against his sister laws. My lord, his daughter married with the petitioner, my lord. Some miscommunication is there and material dispute is there, my lord.
We will consider at the time of hearing. Today we will engage the amicus. Heard, Mr.
A. Rahman.
Learned counsel for the applicant, Mr. B. Sharma, learned additional PP. For the state respondent number 1. Mr. Sharma apprised this court that service upon respondent number 2 is completed. Respondent number 2 is completed. But no one entered appearance on behalf of the respondent number 2. And accordingly, Sneha Kolita is a regular. Or PR during.
Here during, Tapan Ranjan during.
Tapan Ranjan Devi be appointed as amicus to represent the respondent number 2. Let's list the matter on Friday then. Friday. And rest shall also reflect the name of Mr. T.R. Devi in the cause list. And furnish the application and the relevant papers well in advance. Tuesday. Tuesday. Okay, Tuesday.
Obvious.
40.
My lord, yes, notice sir. My lord, in this what happened, when I filed this case, the charges was not submitted. After filing of this, I found the record. The charges submitted on 6/7/2026. So record has come. So matter taken up on Friday. In the
Coming Friday.
Friday, my lord.
Okay.
And private party also appear
Okay.
on Friday.
Or Mr. Ahmed, learned counsel for the applicant, Mr. Parasar, learned additional PP. For the state respondent and Mr. Your name, please? S. Islam. Learned counsel for the respondent number 2. On the pair being made by Mr. Ahmed, learned counsel for the applicant, rest shall list the matter on Friday.
7. Items for admission, item 20. On the other day, my lord have asked us to mark the records, my lord. I've done it, my lord. Here is the person before your lordship is the wife of the accused, my lord, who has issued the check. NI case, my lord. The check was issued by the husband of the petitioner, my lord. There was an agreement between the complainant and the accused number 1. The accused number 1 is the husband of the petitioner. And she has been arraigned as a accused in the NI case, my lord. And the cognizance was taken, my lord, under 420 of the IPC and NI 130 of the NI, my lord. Now, she neither have issued the check, neither she entered into an agreement with the accused, my lord. With
Whether
the
that
complainant.
agreement is part of the record.
Yes, my lord. I marked it, my lord.
Okay. So the petition is for quashing the proceeding against the
Against the
wife.
wife. Okay.
So the wife is not a party to the agreement.
No, no, and then neither she had issued the check. Check was issued by the husband. Ma'am.
Hmm. So what is the allegation in the complaint against her?
That she and her husband went to their home to make a settlement. And she had received the
To make a
notice.
settlement.
Yes, but agreement was done by the husband, and she had received the notice under the NI Act. That cannot be on ground to arraign a person.
He has received the notice
Notice
issued to the
issued.
husband, to her husband.
Yes, yes. Notice is, I have marked the notice, my lord. It's there on the record. In the flag mark, I have written it. Ma'am.
Yes. Lordship, the present respondent lordship, Madhav, the respondent lordship, filed 3 NI cases lordship and 1 money suit. Against the lordship, accused number 1 lordship and against the petitioner lordship. Is it the part of the lordship?
No, sorry, I could not follow.
And initially lordship 3 NI case was filed against this petitioner and her husband lordship.
Earlier.
Earlier lordship. It is mentioned in the agreement lordship as clause number 4 lordship. In the agreement. Clause 4 lordship in the agreement. There are lordship A, B, C, D, E, and F lordship. In C lordship, surplus C. It is clearly mentioned lordship NIA case number 118 of 2008. This NIA case was filed against the petitioner and her husband lordship. And thereafter lordship D lordship, clause D lordship, this is the PS case lordship, this was also filed against the petitioner and her husband lordship. And these 2 cases were pending, and these all cases were settled lordship in this agreement. And thereafter lordship.
No, our question is whether she was a party in this agreement.
She was not party lordship.
Not a party.
No party.
And who had issued the check?
Check was issued by her husband.
Husband. So
Both
how
when
can you array her as a party in this proceeding?
She was initially the case was there lordship, and for discharge their liability, her husband issued the check lordship, 3 check lordship.
Hmm.
From out of the 3
No, who had issued the earlier check?
earlier check was issued by husband from the joint account lordship, husband and lordship that
No, who signed the account? No, who signed the check?
both of them signed the check lordship.
Is the check part of the record?
No lordship.
No.
No, this is another separate proceeding lordship, that's why it was not connected. Therefore, lordship, the trial court lordship, the taken cognizance of under 420 lordship. 420 of course they are lordship.
But how the ingredients of the offense under section 420 IPC is made out against her?
For the lordship, compromise was there lordship.
Hmm.
After when compromise was taken place, the petitioner and her husband,
She was not a party to the compromise agreement.
she was not party lordship.
Then
But lordship, to discharge their liability lordship, the check was issued lordship.
no, NIA case cannot be said to be made out against her.
No, can I
Can you show me any authority that a person who has not issued the check can be arraigned as a party in the NIA case?
lordship, but is there lordship that the 420 section is there lordship, taken
Hmm.
from that is lordship.
Hmm.
420 is there.
420 may be there, but she is not a party to the agreement.
Yes, Lordship.
Then-
But ingredients they are Lordship, because after when the agreement was executed, Lordship, they approached the Lordship, response number two for settlement, Lordship.
Mm.
The petitioner and her husband approached the response number two for
Mm.
settlement, Lordship. They have insisted for the settlement.
Maybe
Thereafter,
that does not mean that she has the intention, required intention to seat you.
Yes, definitely this is intention, Lordship,
How?
because they have approached the response number two
How?
for giving this agreement. Thereafter, again, the same, this not also, therefore, this NI case again, we have filed NI case also.
Oh, who had signed the check, he is a party, that's all right. But the wife who had not signed the check,
She has not
who is
signed
not
the-
party to the agreement.
420 is there, therefore, also 420 is there.
Mm.
Because the second time check was issued to discharge their liability also. Because amount was due.
No,
therefore,
you have no document to show that she has liability in the earlier case. Where is that document?
No, this is the agreement was because in this agreement is clearly written lordship.
Mm.
This is the secret lordship, surplus C lordship, clearly written lordship. Surplus C and D.
Mm. Whether this money suit number 3 of 2008 and Mizze case number 7 of 2008 are part of the record?
No,
Not.
no. Because
Then
all
how
the
can
three-
you-
all the three cases, all the three and I case one money suit.
Mm.
All lordship taken into this agreement lordship and the agreement was executed and thereafter lordship, they issued the check, their husband issued the check.
You bring on record this NI case number 73 of 2008, 74 of 2008, money suit number 3 of 2008, Mizze case number 7 of 2008, NI case number 118 of 2008, Lahwal PS case number 13 of 2008, 56 of 2008, and 245 of 2008. We'll see thereafter. You file an affidavit. Heard Mr. Monir, learned counsel for the petitioner, and Mr. Your good name, please.
N of response number two.
N.
N of.
A. Nath, learned counsel for the respondent number 2. Mr. Loskor for the respondent number 1. State is a party here.
Yes.
Respondent number 1. After hearing learned counsel for both the parties, it is provided that learned counsel for the respondent number 2 shall bring on record. These case numbers are there in prayer number 4. By filing an additional affidavit. Rest shall list the matter on fixed date 19 August as parted.
There is interim order.
Interim order pass earlier shall continue.
Please, Your Lordship. Lordship, it's in 482 application, Lordship. If Lordship goes to the initial order that was passed on Lordship 8/4/2021. The case diary of the dispute police station was filed for 8/4/2021.
Where is that order? Impugn order?
8/4/2021.
Parent or page number?
Initial order, Lordship.
No,
no.
the order which is being challenged in this.
No,
case,
we are not challenging the order, Lordship. We are in fact coming for quashing of an FIR, Lordship.
Where is that FIR?
Lordship will find that FIR at page number Lordship, it start from page, 34, and the operative portion of the FIR will find at, Lordship, at page 37. Lordship, there is an order passed by this honorable court on 8/4/2021, calling for the case diary. But the case diary hasn't been received.
Case I received.
In this case, finally for Lordship, finally for on 6/12/23, Lordship.
On
6/12/23. Finally for submission,
before the trial court.
Lordship.
That record has to be called for now.
Yes, Lordship.
Yes. Finally put it submitted, Lordship. Then finally put submitted, Lordship.
That's all right. The final report has to be called for now.
Lordship.
Final report,
Because crossing of FIR, Lordship, when final report is submitted, then
this petition become infractious.
Lordship. Lordship,
But the final report is not available before the court.
that report will be called.
When it was submitted,
The submission on 6/12/23.
6/10.
6/12/23, probably. Case is closed also because
Before the court of learned.
that is not there, Lordship, only that. Today in the morning I have collected. That is- Authorization fee
this police station.
Kamrup. Yeah,
from jurisdiction.
Kamrup.
Metro.
Are you sure that a final report is submitted?
Lordship, I'm not sure, Lordship, Lordship led the prosecution.
In the morning I have collected that report on telephonic instruction, Lordship, that if they have. said-
Final report
Ought
submitted.
to have been on, before your
Heard,
Lordship.
Mr. Your name, please?
G Das, Gitartha Das, Lordship.
G Das, learned counsel for the petitioner, Mr. Locker, learned additional PP for the state respondent. Referring to order dated 28/4/2021, learned counsel for the petitioner submits that the prosecution side was directed to produce the case diary before this court. But today, Mr. Locker, learned additional PP, apprised this court that the IO has submitted final report in this matter on
On 6/12/23.
6/12/2023, being final report number
5523.
5523, dated
6/12/23.
6/12/2023. Accordingly, it is provided that recess shall call for the final report from the Court of Learned Chief Judicial Magistrate Kamrup M,
As well as present status of the case may be called for. Because
as well as the present status of the case, fixing the matter on 20 August.
Deeply obliged, Lordship.
Lordship, the petitioner, this is a petition under 482, Your Lordship, against a complaint case of perjury, Your Lordship. The petitioner was a headmaster of a school, Your Lordship. During lockdown, certain people encroached upon the land of the school and started some construction. At that point of time, being the headmaster, he placed it before the committee of the school and an FIR was lodged. That FIR proceeded, Your Lordship. Thereafter, those persons who were building those persons who were constructing, they filed a title suit stating that this is a part of their own land. And in that title suit, the headmaster filed a counterclaim. And thereafter, in the counterclaim, certain allegations were made that it did not belong to them. During the course of these two things, Your Lordship, the persons who were constructing filed a petition, filed this complaint case, which is at page 24, annexure 4, alleging perjury, pointing out there are certain discrepancies in my FIR that had initially lodged at the time of lockdown, stating that they are constructing in my land, and in the counterclaim that I have filed before the court. The allegation of perjury is that I have made false statements on oath before the courts because there are discrepancies. In one place, I am saying the date of their entry into the land as a separate date, and in the FIR, I am stating a separate date. That is the crux of the issue, Your Lordship. I am here for quashing of that complaint case, Your Lordship, on perjury. Because, Lordship, on the previous occasion, I sought some time to seek the status of the civil case, Your Lordship. I have sought some information and it is pending, still pending. It is transferred from one court to another and is pending. Be that as it may, Your Lordship. Now, coming to the facts, back, Your Lordship.
You are Jalaluddin Joaddar.
Jordan. I am the headmaster of a school named Simaltapu High School. I used to be the headmaster. Now I am retired, Your Lordship. I'm no more connected. Headmaster of a school, Simaltapu High School, which is situated at Kokrajhar district, Your Lordship. And I have retired, Your Lordship. Thereafter, in the year 2020, Your Lordship, at the time of lockdown, at page 16, Your Lordship, it is the photocopy. The type copy is at page 14, annexure 2. I have informed the SDO Civil regarding to take necessary action in the
So
matter.
upon this complaint, cognizance was taken.
Lordship.
Whether cognizance was taken upon this complaint
Yes, Your Lordship.
under section,
Cognizance was taken, Your Lordship.
under section,
On this complaint case, instant complaint case, which is under challenge.
Mm.
Lordship, the complaint case which is under challenge, Your Lordship, it was taken under section
Page 42.
page 42. (193, 196, 199, and 200, Your Lordship. And my case is that the mandate of 195 is not followed here, Your Lordship.
Who is the person who has to file this complaint?
The court, Your Lordship.
Court.
Yes, Your Lordship. Here, what happened, Your Lordship, the orders, if we go to the orders one by one. Initially, the complaint was filed. Lordship may peruse page 35, Your Lordship. The complainant is present. I deem it fit to conduct a preliminary inquiry to ascertain the facts of the complaint so submitted. Complainant should do the needful on the next date. Preliminary inquiry. Fixing a date for preliminary inquiry. This is before JMFC Gosaigaon, Your Lordship. Thereafter, complainants are present. Complainant has submitted affidavit on complaint number 1 and complaint number 2 and witness number 3 in separate sheets tagged with CR, fix so and so for orders. Thereafter, Your Lordship, order dated 2/4/2024. Today, the case is fixed for order. Complainant site is present. Preliminary inquiry conducted. Hard perused. The principal concern raised, alleged by the joint complainant is that
Section of 195, sir, to say?
185.
195.
That was, but my lord.
Except on the complaint in writing
yes,
of that court.
Some negligence is there, my lord. My lord, but the crux of the matter is that, my lord, as per the.
No, we are not on the merit of the matter.
My lord.
Oh, whether you are entitled to file this complaint or not.
My lord may then do one thing, my lord, may send it back to the learned trial court, my lord, and let him decide again afresh, my lord. Whether on a complaint being received by a private individual, this can be initiated.
No, why should we not examine the matter? Why should we again ask him to approach the trial court?
Because facts remain that they had made some statements, my lord.
That is a
Because of
different
which
aspect.
PRC case was initiated.
That is
and
a
that
different
PRC case has
aspect
been dismissed
altogether.
as of today, my lord. Are they all filed in
This
185?
mandatory provision is violated.
But otherwise, 195 is not for the fact. Because the magistrate has to give a forwarding matter. Saying, hearing the fact of the person.
It is for the satisfaction of the court, your lordship. Court will have to be satisfied that there was some perjury. Only that case, these provisions can be invoked, your lordship, 195. And here it is filed by the private parties. Okay.
Make sure that it's been.
That decision of Supreme Court in that famous case.
James Kunjwal, your lordship. I am referring to one James Kunjwal versus State of Uttarakhand, your lordship.
No, that Bhajanlal.
Bhajan 1982.
Bhajanlal case.
1982.
That is can you
1992 assessment. Bhajan.
Bhajanlal is the president. No, network. So anyway, when the cognizance is taken ignoring the mandatory provision of law, the proceeding can be quashed. Here also, there's a section 195 is violated. So this proceeding, CR case number so and so has to be quashed, and accordingly we will quash it. We pass the order.
Item 23.
Here in this case, lordship, the case was dishonored accordingly, complaint was filed. He was convicted by 2 courts, lordship, and this is concurrent finding is there. As per last order also, I have prepared this, but I have received an instruction to yesterday, lordship, from my client that he wants to talk with the complainant regarding some settlement, lordship. So if your lordship permits, then High Court Mediation Center, maybe both parties may be directed to appear.
No, are you really interested to settle the matter, or you are buying time?
No, so he's really interested, and already he has got 1,70,000.
But you have not contracted till now, is it? Whether he has contacted you?
No. Yesterday I have received instructions. Already he has paid 1,70,000 out of the check amount of 6 lakhs. 20% deposited during the appeal period, already deposited. And around only 4 lakhs.
So can we refer the matter to mediation?
If he interested to know.
Who is interested? That lordship can record it.
Heard, Mr. Ahmed, learned counsel for the petitioner, and Mr. Your name, please? Learned counsel for the respondent. Mr. Ahmed, learned counsel for the petitioner, submits that yesterday he has received instruction from the petitioner that he is willing to settle the matter with the petitioner.
It was in further or so. And it is not initiated probably. And that has been
At what stage the trial is pending?
that we cannot say.
Charge sheet has been filed, your lordship.
Charge sheet filed or say no, TCI has not.
No, whether any witnesses have been examined.
TCI not called for probably or say only the report called for also from the IO.
And your lordship, in this matter, the informant is the sub-inspector himself in the FIR, your lordship.
What's wrong with that?
Your lordship, there is no independent witness, your lordship, in this matter, as far as the FIR that is submitted, your honor.
So, Why should we disbelieve the police officer?
Your Lordship, I'm praying for a presumption in this favor, Your Lordship, since there are no independent witness. And since in the seizure list also, they have been unable to record.
No, is there any proposition that in absence of independent witnesses, the evidence of police witnesses shall be discarded?
No, Your Lordship.
Then,
But Your Lordship, that grants a presumption, Your Lordship.
mm,
Your Lordship, if custody is granted of that vehicle, it will be of interim nature till the final disposal of the case. And the confiscation proceeding that starts after the conviction, if it happens at all. And
so is there any decision of Supreme Court on this point? Releasing seized vehicle involved in NDPS cases pending trial.
Your Lordship, I have
Then let it be tomorrow. You find it out. We'll list the matter as parted. Heard, Mr. Your name, please.
S. Talukdar.
Learned counsel for the petitioner and Mr. Lawcourt, learned additional treatment for the state respondent. Mr. Lawcourt has produced the report from the officer in search Algapur Police Station, Hailakandi, person to the order dated 24/7/2024. And 17/7/2026. List the matter tomorrow for further consideration.
Item 25.
By the instant malad petition, I have challenging the malad criminal proceeding FIR as well as malad rejection of discharge malad application malad. And finally, see malad order dated 4/6/2026 malad. There is a observation malad interim order will be considered after filing of the reply by the respondent bank malad.
So you are for respondent number 2, 3, and 4.
Yes, sir.
You have filed your reply.
Yes, Your Lordship.
When?
Your Lordship, 7 days may be given to me, Your Lordship.
7?
7 days may be given. Otherwise, it is prepared, but due to the non-having of the manager, we could not able to file.
But the problem is malad last malad first 8 malad 6/8 malad it was fixed for malad prosecution witness malad.
On?
Immediate 6/8 malad. 6th of August.
6th of August.
Today 4th of August.
Was called for, that is also not.
This year not received. So let it be on Monday then, next Monday, 10th of August.
Malad.
I'll file it in the meantime.
Heard, Mr. Patgiri, learned counsel for the petitioner, Mr. Lawcourt, learned additional PP for the respondent number 1. Mr. Sharma for the respondent number 2, 3, and 4. Mr. Sharma submits that he may be granted 1 week time to file. Reply. As the concerned manager is out of station. Mr. Lawcourt has pointed it out that the TCR was called for and the same has also not been received. Accordingly, it is provided that recess lays the matter on Monday, next Monday. And recess will also issue urgent reminder to the learned trial court for transmitting the scanned copy of the record. And in the meantime, Mr. Sharma shall file the reply. List on Monday.
I may be allowed to malad file adjournment petition malad on 6/8 malad. If the evidence is start malad, there is no remedy malad. 6/8 malad is the evidence
Maybe on that day you file an application there.
my lord. That observation, my lord, maybe.
What?
Otherwise, my lord, it was, my lord, proceeded, my lord.
No, you see, your interim pair today could not be considered due to absence of his reply. So he has assigned the genuine cause that manager is absent.
Evidence, if the evidence will start, my lord, then, my lord.
Maybe you,
Only the first date of the. This is not an evidence can start also before that question.
Only observation, my lord.
no. On Friday, oh, no, sorry, on Monday, we'll consider your interim pair. Yeah, it is further provided that in the event of failing to file a reply on that day, the interim pair of the petitioner will be considered.
Oblige.
In this case, we have filed an IA for implicating the informant in the criminal petition. So, my lord, IA may be disposed of first, my lord, implementing the, and notice may be issued to the informant.
Mr. Locker, any objection in allowing this IA? No. Heard, Mr. Sigdar, learned counsel for the applicant, and Mr. Locker, learned additional PP for the state respondent number 1. Mr. Sigdar, learned counsel for the applicant submits that the applicant herein has filed one criminal petition being criminal petition number 989 of 2026. And inadvertently in the said petition, the informant has not been arrayed as respondent number 2. And in order to dispose of the said criminal petition, there is a requirement of arraying respondent number 2 as the informant as respondent number 2. And accordingly, he is contended to allow this application. Mr. Locker submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, this IA is then dispose of, and the applicant is allowed to implicate the informant as respondent number 2 in criminal petition number 989 of 2026. And in view of the order passing this IA, Mr. Sigdar, learned counsel for the petitioner, shall file amended petition within a period of 1 week from today.
My lord, notice may also be, notice to also go, my lord, to the respondent.
You first file the amended cost title, only then we will issue notice.
My lord, cost title will only to the effect of cost title, my lord. That I couldn't file today, my lord. Tomorrow, my lord. Tomorrow. Cost title will
Okay,
file.
then recess and raise the matter tomorrow.
My lord.
None appears for the petitioner on call. However, Mr. Locker, learned additional PP present. List the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
May please your lordship. So it's a regular bail application, my lord. Section 12 of the POCSO Act is there, my lord, along with section 87 BNS and 74. Petitioner is in custody for 257 days, my lord. Well, out of 5 prosecution witnesses, my lord, cited.
How many days?
257 days, my lord. 8 months and 15 days.
COVID. Heard, Miss, your name, please? Learned counsel for the petitioner, and Miss?
Miss B. Chaudhary.
B. Chaudhary, learned counsel for the learned amicus.
Yes, sir.
Amicus. For the respondent. The learned amicus for the respondent submits that earlier, Mr.
Late J.M. Chaudhary.
Let James Chaudhary entered appearance in this matter, and as such, she is not interested to proceed with this matter, and she applies for relieving her from this matter. Prayer allowed. Ms. Chaudhary is released from this case, and who can be? Sneha Kolita or Dipti Pathak. Kitlo kala nimisok dilo na. Sambitas katone. Ahe. Sahina Nazneen as amicus in this matter and raises and lays the matter on
14.
14. 14.
Oh, sorry. 14, 15. It's a hearing that-
18. 10. Raises shall reflect the name of Sahina Nazneen as amicus in the cause list and furnish the relevant papers to her well in advance. List accordingly.
44. 44.
Lordship, last two occasions they have not appeared, Lordship, and they have to charge us complete copy also. Then also I want to submit, Lordship. This is criminal litigation against the order passed by the public Lordship. Second, here no appeal shall be live, Lordship, under section 438(3), Lordship of BNS. Case is not maintained. Kindly have a look, section 438(3), Lordship. Revision before the sessions court. Under section 390.
For
438 BNS.
this is against interlocutory order.
No, Lordship, final order, they have come before the session court under section 397 and 399 of CRPC. Lordship, for revision, Lordship. Here again come for appeal, Lordship. There is no scope, Lordship, because 438(3), it bars. If an application under this section has been made by any person, either to the High Court or to the session judge, no further application by the same person shall be entertained by the other of this. 438(3). And 440 also bars, Lordship. 438 and 444. Oh, sorry, 440.
For 40.
440, 3, Lordship. Here also 3, where any application for revision is made by or on behalf of any person before the session judge, the decision of the session judge thereon in relation to such person shall be final, and no further proceeding by way of revision at the time of instance of such person shall be entertained by the High Court or any other court.
Okay, none appears for the appellant on call. However, Ms. Bora, learned. You are amicus here.
Yes, sir.
Learned amicus for the respondent present. Ms. Bora, referring to subsection 3 to section 438 and also subsection 3 to 440 of BNSS 2023 submits that this appeal is not at all maintainable in view of the fact that the appellant herein has preferred has preferred one revision petition before the learned session judge Bongaigaon. Being criminal revision number 5 of 2023. And the same came to be dismissed. Came to be dismissed, and therefore this petition is not maintainable. However, in absence of the appellant, the submission of Ms. Bora could not be considered today. And accordingly, it is provided that recess shall lays the matter on fixed date.
On 20 August.
28 August.
Maybe given because they have not appeared.
And in the event of subsequent non-representation of the appellant, appropriate order shall follow.
45.
No, no, sir.
May it please your lordship. Lordship, here the accused persons are sentenced to 10 years imprisonment. Lordship. It is against the judgment and order dated 5/2/2025, Lordship.
10 years.
10 years, Lordship.
Under section?
Under section 307
Seven.
and 326. Mainly, Lordship,
The injury was grievous in nature,
injury was grievous in nature as part in.
where it was inflicted, which part of the body?
Head, neck, etc.
Vital part of the body. As per medical report, it is grievous.
Lordship, that part, the medical investigation of the police, Lordship, somewhat sketchy, Lordship, because what the medical has been provided, it is provided by the family members, Lordship. It was not collected by the police, Lordship.
Maybe.
Lordship. Then the medical report,
Doctor was examined.
doctor was examined, Lordship.
Doctor has proved the report.
Lordship, there was delay of filing the FIR for, Lordship,
Maybe.
there was sufficient delay in filing the FIR, Lordship.
How many days?
About
It was discussed in the judgment matter, but victim, he was injured, he was in the hospital for 10 days matter. Thereafter recovery, he has filed the FIR.
Lordship,
That was properly discussed in the matter.
Lordship, from the evidence of the wife, Lordship, she has given the evidence, Lordship, that she has informed, since the 307 is invoked, Lordship, she has informed the police about the incident, Lordship. The police neither produced any GD entry nor produced anything in that regard, Lordship. The delay has been not explained, Lordship. Moreover, Lordship, in the judgment, Lordship, page number 29 of the appeal, that is the judgment, Lordship. In the present case, there is no eyewitness to the assault mounted upon the victim PW1. Lordship, no eyewitness. Lordship,
Maybe. Whether the victim has not identified you,
Lordship, they have identified me,
then
but their, Lordship, the statement, Lordship, there was a previous enmity between the persons, Lordship. Previously also, case was lost against him, Lordship. And Lordship, since they were acquitted, Lordship, here the witness PW1 on which.
no, we are not concerned with the earlier case. We are concerned with the present case where you have been convicted.
Yes, Lordship. In the present case.
So you
Lordship,
are serving out the sentence. You are behind the bar now.
yes, Lordship.
Okay. For how many years?
Or about, Lordship,
Judgment was 5/2/2025.
23,
25.
25.
1 year, 6 months. 1 year, 6 months.
And imprisonment is for 10 years.
10 years.
10 years.
Under section 307.
Lordship,
So the victim has identified you.
Yes, madam. From the PW1 matter.
Lordship, although
Yeah.
the victim has, Lordship, the victim statement, although
he has said the victim has identified me, Lordship. The victim statement is not, he has a contradictory version of his own statement.
Maybe minor contradiction may be here
No,
and there,
no,
but
Lordship,
that cannot
not
be
a-
the
not
ground
a-
to discard his evidence.
Lordship, it is not a minor contradiction. Lordship.
Hmm.
It is not a minor contradiction.
How?
Lordship, PW1 statement, I am going to the PW1 statement,
Hmm.
Lordship. I am the informant of the case. I know the accused person as my neighbor.
Hmm.
Ashok Vaishya is my younger brother, Lordship.
Hmm.
The incident took place on 24/06/2019 at about 9 p.m. My brother Ashok Vaishya returned from work. We both brothers stay separately at a distance of about 20 meters. I was inside my house at that time. At that time, Rajiv Sakya, Sandan Sakya came to commit theft of Sasi tree from the compound of my brother. And the same was told to me by my brother Ashok Vaishya.
Hmm.
On hearing the shriek of my brother, I came out from my house with a torch in my hand. At that time, other village folks also came out. On hearing the shriek of my brother, I, along with other village folk, went out of our house. And till then, I was not aware who were the thief, Lordship. We started searching for the thief in a field for a distance of about 100 meters from our house. I came face to face with Chandan Sakya and he came out from the nearby jungle. Chandan Sakya from my, it was at 9 at night, Lordship. Chandan Sakya from my front attacked me with a knife, Kalam Kotari. This was not chased, Lordship. This Kalam Kotari, the weapon was not chased and gave blow of my neck, on my neck, near my left ear, and also on my left cheek, below my left eye. When Salman Sakya tried to attack me with more blows with the knife, I caught hold of the knife with my left hand. And at the time, Rajiv Sakya, then Rajiv Sakya came out of the jungle and with a dao assaulted me on my head. I was almost on the verge of losing my senses, but I somehow rescued myself from their clutches and raised hue and cry. On hearing my shout, other village folk who were already outside met me and took me first to Amguri Hospital. Lordship, this Amguri Hospital, no person from Amguri Hospital has been examined, Lordship. No officer from medical officer from this Amguri Hospital has been examined, Lordship. And immediately thereafter,
So he was taken to Jorhat Medical College and Hospital. There he was examined by the doctor.
Lordship, first they took to Amguri Hospital, Lordship.
Maybe.
Lordship, first they took to Amguri Hospital, and immediately thereafter, I was taken to GMCH. Lordship. Jitu Dwara, this is important. Jitu Dwara, Bhupen Gogoi, Mohesh Setia, Papu Dwara, Babul Dwara, Horen Gogoi, Khogen Gogoi, Jodumuni Dwara, Ojit Dwara were among the village folks whom I just met immediately after the occurrence. Lord. I told them about the accused persons that they had attacked me and injured me. Lordship, these persons were not a witness to the case. Lord. These are not witnesses.
When the occurrence took place?
Occurrence took place on 24/6.
24/6. And he was examined by doctor of JMCH on 25th of June 2019 at about 4:43 a.m.
Yes, sir. I told them about the accused
suffered
person.
his left hand, throat left side, and head left side. Fracture in left temporozygomatic arc anteriorly and posteriorly, with minimum lateral displacement of anterior part is grievous in nature. So fracture is there.
Like in one part, it is also mentioned.
Life threatening.
Lordship, this
10
incident,
years is 10 years is less.
Lordship, this incident is doubtful, Lordship. Because Lordship,
10 years is 10 years appears to be in lesser in
Lordship, after that, I had given stitches on the left neck, head, left cheek, and left hand. On being released from GSA, I came back to Sibsagar and lost the Azehar. Azehar 1 is the Azehar wherein Exhibit 1 is my signature, Lordship. Here, Lordship, the last part, Lordship. On the next day of the incident, when I was hospitalized at GMCH, my brother Ashok Vaishya, Lordship. This Ashok Vaishya, who is the brother of the informant, went to visit me, and he told me that it was Rajiv Soikia and Chandan Soikia who had come to commit theft of Sasi tree on the night of the incident, and he had seen them with the help of a torchlight. Here, Lordship, the statement differs, Lordship. Now,
maybe in this PW1, the victim and informant clearly stated that it is you who have cut him.
Lordship, these persons are not victim stated,
Accused,
but it has
you see
contradicted
his statement, accused Chandan Soikia then attacked me with knife by giving blow on his neck near his left ear and also over his left cheek below the left eye.
Lordship, in the last part, he has itself contradicted his own statement, Lordship.
What is statement?
On the next day of the incident, when I was hospitalized at GMCH, my brother Ashok Vaishya went to visit me, and he told me that it was Rajiv Soikia. Lordship, it was not his version. It was his brother told him that it was Rajiv Soikia and Chandan Soikia who had come to commit theft of Sati tree. On the night of the
that
incident.
Ashok Vaishya is not examined here as witness.
Not examined. It is fatal, not examined as witness. Lordship, one of the witness has even seen the person next day, Lordship. That was not given importance, Lordship.
No. Whether on the date of occurrence that person has seen the accused.
Next day, no, Lordship. The accused person has seen the informant.
No. Is it your case that Ashok Vaishya has also seen the occurrence and he has not been examined?
Lordship, it says that on the next day of the incident, when I was hospitalized at GMC. My brother Ashok Vaishya went to visit.
What other points you have? Except this contradiction?
During, Lordship, except this contradiction, I am coming, Lordship. The last part also, during my hospital at GMC, my wife, Dipti Borwa, verbally informed at Halwa Singh police about the incident. The police then and told that she should wait till I am discharged. This fact, since the incident is a serious one, this fact has not been entered as a GD entry or something else.
Whether you have questioned the IO in this regard?
Lordship, I am coming to the IO, Lordship. IO has
No,
not
my
even
question
said-
is whether you put any question to the IO regarding the information given by the wife of the victim?
Lordship, the wife. Lordship, here.
No, you first answer my question.
Yes, Lordship.
Whether you put any question to the IO in that regard?
Lordship, that was most probably left out, Lordship.
Then?
Lordship, it should have been on the record, Lordship, since the investigation was carried on in a
No,
process.
whether it
Lordship,
was on the record or not, you never questioned the IO during cross-examination.
Lordship, in
Did
the-
you?
That was not examined, but Lordship may go through that the medical documents provided was not collected by the IO, Lordship. It was provided by the victim person, family of the victim persons.
Is there any bar in producing any medical document by the victim or his
Lordship,
family member?
It is not a bar,
Then-
but Lordship,
Then?
since there was a 7 days gap or 7 or 8 days gap in filing the FIR, Lordship. Since
Now
the
that has
police-
been explained by the victim, by the
Lordship-
informant.
Lordship, that should has been verified by the IO.
Hmm.
It was never verified. The IO never verified that if he was admitted to the Amguri hospital, Lordship.
Hmm.
Because the preliminary part was that he was admitted first to the Amguri hospital. Then he was sent to GMCH, Lordship. Lordship, in the statement, cross-examination, Lordship, of the PW1, Lordship.
Hmm.
After Lordship, I lost the FIR on 2019. The SIR was not written by me. I know the contents of the FIR. Police did not record my statement, Lordship.
Hmm.
Police did not record the statement, Lordship.
Hmm.
Later on says that the police recorded my statement in my house. After 2 days, later on says that his statement is shaky, Lordship.
Hmm.
After 2 days of my release from the hospital, police recorded my statement. I have stated before the police that both the accused person, Rajiv, tried to attack me with a knife. I did not state before the police whether any persons from my village were present and or not at the time of the incident.
Hmm.
He did not state, Lordship, but I did not state before the police that Jitu Dwara, which he has state examination in chief, that Jitu Dwara, Bhupen Gogoi, Mohesh Setia, Papu Dwara, Babul Dwara, Horen Gogoi, Hogan Gogoi, Jodumoni Dwara, Otul Dwara came to the place of occurrence, hearing my hue and cry, Lordship. Here the statement says, Lordship.
Hmm. No, some sorts of contradiction may be here and there, but the question is whether those contradictions raise any doubt about the veracity of the person of the informant, because he is the only witness of the case. He is the injured witness. Therefore, he appears to be more credible.
Lordship,
His evidence appears to be more credible.
Lordship, he although stated at first, later on he changed his statement that my brother told me, Lordship.
No,
Yes, Lordship.
in chief, he has clearly stated that he has seen the accused.
Lordship, he has seen the accused, Lordship, at night with a torch. Lordship, the place of
Whether
occurrence,
you
I
have
have,
disputed the identity.
Lordship, I have examined the,
No, whether
Face
you have
map.
disputed the identity.
Lordship, the incident said to have occurred, did not occur, Lordship, because from the documents submitted by the as medical does not say what
Better you
weapons
do
was
one
used.
thing. You prepare one written argument highlighting the points you have raised today. We'll see. Heard Mr. Borua. Learned
I'm interested.
S.J. Sharma, okay. Learned counsel for the appellant, and Mr. B. Sharma, learned counsel for the respondent. Learned additional PG for the state respondent. Heard in part, place the matter for further consideration on next Tuesday. Next Tuesday. Yes, part heard.
In the cross of the PW1, they have failed to make any contradiction measure.
No, therefore,
Put to the PW1, but they have
therefore,
in the from the team method. And it is in the method page it was stated method. The same swabab could not be proved by the defense through the IO method. They could not prove the defense through the IO method. They never put the question to the IO method to prove that method regarding the contradiction. That is also there.
One witness PW5, he has stated on the next day I met.
No, PW5 has not seen the occurrence.
My lord.
He is not the eyewitness.
My lord.
Lordship, although no, he is not the eyewitness, Lordship, he is PW5.
No, his evidence is hearsay.
My lord. Yes.
Lordship, not hearsay, Lordship. He PW5 has stated on the next day I have met Ranjit Boisro. He told me that two tapes stabbed him with a lordship. How can he met in the next day, lordship?
Whether Ranjit Boisho is
Lordship,
examined.
he was declined cross-examination, lordship. On the next day, I met Ranjit Boisho, lordship, the informant, lordship.
Hmm.
He has said that
No,
he has
no,
met the next day,
only
lordship.
the eyewitnesses are to be taken into account.
Lordship, eyewitness only, he is the eyewitness, but his statement is
Only,
contradicted by.
we'll consider only his evidence.
My lord,
We'll see the cross-examination, how far you are able to demolish the same.
my lord. PW1 is corroborated by the medical evidence by the PW station.
Medical evidence.
It appears that the punishment is in lower side.
My lord, my lord,
Punishment is in lower side 10 years. It should have been 14 years.
my lord.